did not receive disagreement. Listing, yes, what occurred when it can be listed?
Interim order.
Yes, interim.
Deep level.
May I please, Your Lordship, for listing of IA, Your Lordship, for correction of order, Your Lordship, tomorrow, Your Lordship, at 2, the name of the father has been wrongly recorded in the petition. At 2 of legislation.
May I please, Your Lordship? I beg to mention listing of an anticipatory bail application, my lord. It was last posted on
Court number. Court number 8. Make a mention before court number 8.
May I please, Your Lordship? I beg to mention item number 34. The engaged counsel is currently out of station. Matter may be fixed for next week.
34.
34.
Yes, what is the position on 34? Case diary not received. Are you on entry?
Yes. I don't know. I'm not aware. I was in last morning. Wasn't.
Interim is not there, na? I think. We have not received this case diary also. The request that CD is also not received. Estimate recording. 19th, you're saying? 19th. 19th of March.
My lord, arising out of the same affair, on Monday, my lord, the matter was taken up. Case diary was available. This
Make
is
a mention before court number 8. It may be listed before this.
court number 8.
Yes.
May it please, Your Lordship. Sure, I beg to mention item number 33, my lord.
33.
33.
Yes.
CD was called for, perhaps not received, my lord.
33, my lord. Is very not. As per my
Sessions Court of Kamruk.
yes.
Interim is there, my lord. That may be extra.
Sitting. Should remain. Further, it is informed by the Land Division PP, Mr. Portable, that CD may be available in the Court of Transition. Yeah, I will take necessary steps. Procuring the CD on the next step. On the next step. Please do matter accordingly when it can.
My lord, can it be in after 23, my lord?
24.
Deep.
24 3.
May I please, Your Lordship? That's it. Back to mention for listing of order matters, my lord. Criminal petition, my lord.
Make a mention before court number 8.
8. Lordship.
May I please, Your Lordship, I pray for listing of IA in connection with criminal revision, Lordship.
Make a mention before court number 8.
8.
May I please, Lordship? Lordship, in this case, the petitioner is booked under section 118-351, Lordship. So case diary may be called for.
118.
118-351.
CDP call. Yes, what when I can.
In
Well,
next week.
From Sunbury, 10th of March. 10th.
Much obliged.
You are on item number 2?
Yes.
Yes.
Your Lordship, the senior has not come yet.
Huh?
The senior has not come yet.
What is your instruction?
Pass the matter for a time being.
Time being. কি করব লাগে?
May I please, Lordship, item number 3, I want to order the bail petition, Lordship.
Yes.
I want to order the bail petition.
He wants to withdraw the.
Order
You
the
want
bail.
to withdraw?
Yes,
Okay,
Lordship.
okay. Why? Instructions are there.
Yes.
Your good name?
Islam, Lordship.
Huh?
Islam.
I Islam.
On behalf
Imdadul.
of Imdadul Islam.
Part Mr. Imdadul Islam. Done it once with the petition. And also Mr. Report. Additional BP being submitted by Mr. Islam. Just by instructions of this kind. Submission will be done. prior again. Yes, so my petition is disposed of on withdrawal. Yes.
Obliged.
May it please the lordship. My lord, this is a regular bail application, my lord. My lord will kindly peruse the FIR at page 15.
15.
15.
Yes.
My lord, this is registered at Dadora Police Outpost. Your lordship sees the content.
Hmm.
Respectfully, I state that on 16/1/2026 at about 7:30 p.m. to 10 p.m. in absence of the family members, some thieves entered the first floor of my house from the backside, breaking the iron grill of the window and stole away some items. They took rupees 4,20,000 cash from the first almirah and rupees 60,000 from the second almirah. In addition to the cash, they also stole the following items. Now, my lord, there are certain gold items which have been listed. Now, my lord, we'll see the total estimated value of the stolen articles, including the cash, will be approximately 17 lakhs. Now, my lord, based on this FIR, the police conducted investigation, and on page 22, the thieves which have committed this offense, my lord, they have been arrested. My lord will kindly see the brief history, second paragraph. During investigation. During investigation, a reliable source information has been received. An operation has been conducted by a team of Hazo PS at so-and-so areas. During the operation, the accused number 1, Aforesaid Mia, the accused number 2, Saifuddin Ali, has been apprehended and seized their bikes, which were used to commit burglary. The apprehended accused led to apprehension of accused number 3, Juran Ali, so-and-so, and incriminating along with tools, including screwdrivers, were seized from his possession. That after the apprehended accused so-and-so led to the accused number 4, Asar Ali, son of so-and-so, who purchased the new Pulsar bike 2 days before by using stolen money which had been seized. The apprehended accused so-and-so and so-and-so led to accused number 5, Saifuddin Ahmed, so-and-so, who received stolen jewelries. Accordingly, huge quantity of gold, silver, stolen jewelry have been recovered from the possession of the accused Saifuddin. So, my lord, the recovery has already been made regarding the gold and stolen items. And regarding the cash, it has been stated that then one Pulsar bike was purchased on the basis of the cash. Now, your lordship will kindly see at page 23, the grounds of arrest. 3, 4, 5, your lordship will kindly see 6. The apprehended accused so-and-so led to apprehended accused number 5, who received stolen jewelries. Accordingly, huge quantity of gold, silver have been recovered from the possession of the accused, Saifuddin Ahmed. Now, the lordship will kindly see at 7. Seizure by MR number so-and-so and so-and-so were done from the possession of the below noted accused persons, where 2 wheelers used to commit the burglary, and stolen golden color and silver color jewelries, including screwdrivers used to break the lock and Godrej, were seized. Now, page 24. Your lordship will kindly see the name of the accused person. These petitioners are not in this name. Now, my lord will kindly see at page 25. This is the forwarding of the petitioner. Now, my lord will see at last paragraph. Further, the arrested accused persons were remanded in police custody for 3 days. During remand period, the accused persons were interrogated thoroughly, and they confessed about commission of the crime. Thereafter, on being led and shown by police, remand accused Saifuddin Ali and Saifuddin Ahmed. These are the thieves, my lord, the prior that forwarding. So-and-so, led by so-and-so, with staff searched the jewelry shop of Nizam Ali. So-and-so, accordingly, huge suspected gold jewelry were melted, including so-and-so, seized and apprehended the jewelry owner Nizam Ali and 2 more co-accused. Now, my lord, these are the co-accused which are present before this honorable court. Now, my lord will kindly see my grounds of arrest at page 26. These petitioners were arrested on 28/1. Today is 37 days they are in custody. Now, my lord, grounds of arrest. The lordship will kindly see 3 and 4. On being led by police, remanded accused Saifuddin Ali and Saifuddin Ahmed, the jewelry shop of Nizam Ali were searched, and huge suspected so-and-so, including gold melted items, were seized from the possession of the arrested accused Nizam Ali as per seizure list dated so-and-so. Arrested accused, these are the petitioners. Arrested accused Fazal Haq, Rabiul Ali, and Sohidul Islam were apprehended in the jewelry shop of Nizam Ali, who received stolen gold and so-and-so. Now, my lord, since they were present in the jewelry shop, along with the Nizam Ali, they were also arrested. Now, my lord will kindly see the seizure list. That before that, we'll kindly see at page 27.
Yes.
Page 27, my lord, name and address of the accused persons. 3, 4, and 6 are before this honorable court. Now, my lord will kindly see the seizure memo. Page 28. Place of the seizure, Mahanwara Jewelry. 5, from whom seized Nizam Ali. Now, my lord, already Nizam Ali has already moved the bail application. I moved the bail application, and your lordship, after considering everything, your lordship was pleased to grant him bail on 26 days of custody. Now, my lord will kindly see the seizure memo. Description of seized articles. These all seized articles were seized from Nizam Ali. However, in case of these present petitioners, your lordship will kindly see 5, 1 Pulsar bike so and so. This belongs to a petitioner number 3. Next, page 29. Rabiul Ali, 1
Your
classic
petitioner
bullet.
is also he is not a jewelry shop.
No, he is not a jewelry shop owner.
That is the thing.
Yes,
Yes,
and regarding the
I
jewelry
think
shop,
I have granted
Yes,
bail.
yes.
These two jewelry shop owner,
yes,
and where from all the jewelries were which were available in the shop
Were taken away.
seized,
Yes.
taken away without any
yes,
identification.
without any identity.
That will
Correct,
be the reason.
my lord.
But your case is, I don't know. Yes.
Nothing has
Your
been seized also,
lordship,
my lord.
page 26, ground number 4. They are the accused persons who, my
Yes.
lord, sold all these, my lord, jewelries to Nizam Ali.
No, my lord.
Yes, your lordship, arrested accused person, yes. Page 26, ground number 4, my lord. Arrested accused Fazal Haq, one of the petitioner, my lord. Rabiul Ali, one of the petitioner, and Sohidul Aslam. These three are the petitioner of the present case, my lord. Son of so-and-so were apprehended in the jewelry shop of Nizam Ali,
Who received?
who received stolen gold and silver jewelry from thieves
Thieves.
and sells stolen gold and silver jewelry at the said jewelry shops.
Yes.
So, well, they are the persons, well, who received those jewelry, thereafter sold all these items to the shop of the Nizam Ali, man, which is the allegation.
My lord.
Let us see the case diary.
Yes,
Where from it has to come, Hajo.
Hajo.
Azumari.
When it can be what Hajo?
On my lord,
It's on 9.
on 11, 9th of March, I will try, but my lord,
9th.
My lord.
9, but my lord, if not comes, my lord, I
Then
can-
we will. If on 9th it doesn't come, then
Because probability on 9th, I
Because-
cannot say because 8 is a holiday and 7th, maybe.
7 and
Well,
6
I
is
don't know.
7 and 8 is 6 and 7 is open, my lord.
on 9th.
9.
And 7 is open, but probability, I don't know. Anyway, we are
It's from Hajo, that's why, my lord, I am pressing. Otherwise,
Yes.
I would have prayed for 7 days at least. Deeply obliged.
Yes.
My lord, the petitioner is the instructor of Lachitpur Fukan Police Academy. He is known for his strict, my lord, discipline and administration. Some female trainees lodged a complaint before the commander of the academy that the petitioner has sexually harassed those girls. Then the complaint was forwarded to SP and subsequently the FIR has been registered, my lord. Till date, 12 days in custody. I'm praying for a short date, my lord, for the case diary. Otherwise, my lord, there is nothing. In fact, the FIR itself shows that there is no such actions has been taken by the, except some scolding and all, my lord. In police, while training, some amount of scolding may be there, my lord. I am not denying that. But to the extent the FIR has been lodged, my lord, this is absolutely a false story, my lord. And in fact, 35 years of career, not a single incident. He is on the verge of retirement, about 59 years of age. If your lordship, page 10 is the
Page 10 is the.
page 10 is the
very-
type copy, my lord. Yes,
Whatever. It's
my
very-
lord. Because
it's
it was not
a-
also issued, it was also not filed before the police station. They only informed the commandant that these things are.
Obviously, they will inform the commander.
Yes,
Because they
yes.
were under training batch.
Yes,
So next officer is the commander. So
Yes.
he informed all this.
so that's why, my
All
lord, the
these-
short date may be given
all
for the case
these,
diary, my lord.
these things are abusing this not related remarks and all, every these actions and all these things are they
Yes,
from common
informants are all, my lord, lady trainee, my lord.
lady training.
All, and he is the instructor, my lord. The allegations are serious, my lord.
Serious. If CD allegations is not a case of
Therefore, a short date
simple
for
abusing and all. It has to come from which place?
from Dergaon.
Dergaon, my lord.
Yes, Portal.
On, my lord, 24th of March.
My lord, 24th will be, my lord, can it be with the next week, my lord? 24th will be already 12
Next
days in
week, my lord,
custody.
on 17th of March, my lord.
17.
70.
Okay.
Seats.
I'm applying.
Lordship, I have instruction to withdraw this case.
Withdraw.
Oh, withdraw.
Acha. Your good name? Your name?
M. Jamal.
And Jamal. Same order. Okay, we're disposing your case on withdrawal.
May I please, Lordship?
Yes.
Lordship, petitioner was arrested on, my lord, 24 to 2026, my lord. He is behind the bar for the last 10 days, my lord. Lordship, find FIR as page 16, my lord. May I read, my lord? I, the undersigned, have the honor to inform you that I am residing at India campus, Oil India, India campus, Bir Kusi, PS Sadgaon, Kamrup Metro with my husband, that Sri Jivan Das. He is the present petitioner, my lord. Mobile resides at the same campus with his wife. I know him from last 4 years. In the absence of my husband and his wife, Jivan Das used to visit my residence and with his emotional words, trapped me in love. He had physical intercourse with me and he recorded my video and also took photo in his mobile during the process. Thereafter, he began blackmailing me and threatened to make my photo and video viral on internet if I do not give his money. He threatened me that he will send my video and photo to my husband's mobile. Out of fear, I paid him rupees 2,70,000 in parts in the year 2025 from the saving of my husband. He also took my Aadhaar card, PAN card, voter card from me and took loan without my knowledge to purchase mobile. In this way, by blackmailing me, he forcefully made sexual intercourse with me several times at the several lodges in Gauhati. He now and then threatened me to make my photo and video viral and commit suicide if I do not meet. That on 23/1/2026, the day of Saraswati Puja at about 12:30 p.m., he met me in Narangi and thereafter he took me and my minor child 2 years in Over cart to a lodge at Sangsari and forcefully made sexual intercourse with me. He took my mobile phone and did not allow me to call anyone. On the next day, he took me and my child to a lodge at Hauli Borpeta under threatening. In the meantime, my husband lodged a missing report at Sadgaon PS. Police from Hauli and Gauhati came in the lodge and recovered us. Then we came to Sadgaon PS. I narrated all the aforesaid incident before the police personnel, but no case was registered and I was not even medically examined and I was sent back with my husband. Jivan Das now had left Oil India campus, Birkuchi, and shifted to some place at Sanmari hillside. Now Jivan Das again on 6/2/2008 about 4 p.m. called from his mobile number in my mobile phone and threatened me to meet him again and also gave me text message. In this way, I am physically and mentally harassed by him. Therefore, I earnestly request. This is the only allegations, my lord. Lordship, may kindly see at page 26, my lord. And vernacular is, my lord, at page 28, my lord.
Who is Sumidas?
Sumidas. Sumidas is the wife of the petitioner.
Acha.
At page 28, my lord, page vernacular is there, my lord. When the police recovered them from the Hauli PS, my lord, they have bring them to the Sadgaon PS and they have entered into an Apusnama, my lord, mutual agreement that they will not lodge any FIR and they will be sent back to their respective home, my lord. This signature is made by the right hand side, my lord. Ganesh Pradhan, my lord. He is the husband of the informant, my lord. And left hand side, Ms. Sumidas. She is the wife of the present petitioner, my lord. And the next page, my lord, you will find at missing person signs also there, my lord. Jivan Das, he is the present petitioner, my lord, and informant. And there are 4 person signatures there. Married, my lord, this at page
Yes,
28, my
no,
lord.
no, it's
And my lord,
Otherwise, my lord, admittedly, some relationship between the my lord parties is there, but on the pretext of my lord viraling those photographs, my lord,
no,
now he is involved in blackmailing her. It is the main allegation, my lord.
my lord, may kindly,
Otherwise, regarding that, Apusnama only CD will, any short date may be fixed.
my lord, I have also annexed the payment receipt, my lord, page from, it starts from page 30, my lord. She is saying that he is
Okay.
threatening to, for money, my lord, extortion, my lord. My lord, may see, both have transaction, my lord. She have given some money, he has also given money. From, it starts from page 30, my lord. If a person will, my lord, threaten him, why he should pay, my lord? Payment are made from both the side, my lord. And there is no such type of allegation, my lord. And she knows, my lord, for the last 4 years, my lord. And he is working in, my lord, oil India handyman, sir, my lord. So his custodial information may not be required, my lord. Detention may not be required, my lord. 10 days, my lord, already. Nothing is, my lord.
it seems, I just honestly speaking, it seems that these are the consenting party and they were
Yes.
carrying out all these
Yes.
things.
She admitted, my lord, for the last 4 years, my
It
lord.
seems, because the lady will go from here, there and here,
Yeah.
there, it's not
Yes.
case of it. You are Mr. Hawari.
Oh, yes, ma'am.
Hi, Mr. A. Hawari, the learned counsel for the petition. Also, hi, Mr. Keyboard, the learned edition. It's an application. Next, submitted by Mr. Hawari. It is lost by the informant with some false information against him. By this effect, there was some relationship between the petitioner and the victim. And if any sexual relationship was, and if any physical relationship was also there, if any physical relationship was there between the parties was consensual. Most he submitted that it is a there's some money was there was transaction of money between the parties since and to that the petitioner also paid some money to the informed. However, after their arrest and after when they were who caught them? I mean, where from they both the petitioner and the victim were
Initially, they were recovered from Howley,
Howley.
Howley,
By
my lord.
police or what?
My lord?
By police or?
Yes, my lord, by police, but they are subsequently, they were released, my lord. After that, she lodged an FIR on 10th of February, my lord.
It was submitted that after they were apprehended from Borpeta police station, by Borpeta police station. And, they were about to go home, but subsequently some ill advice of some other person, she lost the FIR against the petition. However, before lodging of the petition, the wife of the petitioner and the husband of the victim, that is the informant, also made a mutual agreement wherein the present petitioner and the victim were also put their signatures on. The mutual agreement is also annexed. Mr. Howard further submitted that the accused petitioner got arrested in connection with this case on 24/02/2023, and hence further custodial interrogation may not be necessary for the purpose of investigation. However, it is really willing to extend his cooperation in further investigation if he is released to Mr. Bott should be raised objection and submitted that there may be a mutual agreement between the parties. She brought the allegation of rape and the mental harassment against the present petition, and hence the CD will reveal the actual facts. considering this submission made by learned counsel puts all aspects of the case. And I find that further, this court is of opinion that further custodial interrogation may not be required for the purpose of this. The candidate wishes to extend the privilege of bail to the present petitioners. This Kamrup Metro
Yes, ma'am.
with the satisfaction of Kamrup.
Obliged.
May I please, your lord? My lord, it is a 482 application, my lord. I take your lordship page 12 FIR. My lord, what happened? The bitumen were booked from Gauhati for Arunachal, my lord, in a truck. And the driver, Nuzrul Islam, what he did, he has converted those bitumen at Koliabar and converted it into water and sealed it and delivered it at Arunachal Pradesh. When the owner of those goods has realized that it is not a bitumen, he has ran to the Gauhati seller.
It was
Then-
not bitumen, in fact.
No, to water.
Water.
Water. It is converted by the driver. He has admitted in the FIR. The owner has asked the driver, why you have done it? He said, I have converted it. He has admitted. So, my lord, I am not for driver. Driver is arrested already. My lord, I hail from, my lord, your Samaguri, Isavali. I am a daily labor. Page 16 is the notice of 35. I was asked to appear before the Godship to give some information in connection with the allegation. But I do not, neither I know the driver nor the owner of the anything. Anyway,
you?
my lord,
Who are
I am willing to go, my lord, kindly.
Who are you?
I am a daily labor of the Samaguri.
Daily labor of Samaguru.
Samaguri.
How you are connected with the vehicle?
No, I do not know anything. Nothing of that.
Huge quantity of bitumen, my lord, already.
No, no, but you see, kindly go to the affair, my lord. He has admitted that he has done it. That's why he has taken into the custody by the IO. Page 12 is the affair, my lord. He has admitted it.
This FIR is against the driver.
Yes.
But now, who is
No,
he?
it seems that maybe he is the purchaser of all those bitumen. Maybe, my
No,
lord.
I am not.
At this point. But
I
now,
am-
my lord, submission that he is only a laborer, my lord.
How
If,
he is
if suppose he is a laborer, then, my lord, where is the difficulty in appearing before the?
Hmm.
I am ready to go. That's why I want for little protection.
And-
I am afraid that,
and-
my lord, I am a daily labor. If I am taken into
Yeah,
custody.
what police said, how you are I mean, associated with this crime?
But I am apprehended that if I go there, I will, my lord, 36, 35, 6 also there. If I don't cooperate, that they may arrest me. It is there, written in the notice.
You are from which place?
I am from Samaguri. And it was converted at the Koliabar,
Koliabar, Samaguri under Nagaon,
Yes.
whatever.
Nagaon district, my lord.
But why you are happy? Why you are?
I am afraid because why notice was served to me.
Huh?
Notice was served to me. Otherwise, why should I afraid? Why notice has been served under 35(3) and 35(6). That's why I am afraid to go. But I am willing to go. Cooperate. If I know anything, I will definitely convey.
If he has nothing to do, my lord, why police will arrest him?
Yes.
Someone says, should let him appear, my lord. Otherwise,
I undertake the responsibility of appearance, my lord.
then, my lord,
Kindly-
it may be recorded that, my lord, he is a laborer and, my lord.
Yes, he is a laborer.
That submission may be
I
recorded.
have written he is a daily laborer.
He's a day.
Administrative council. The learned edition, every month. It's an application section, so it's encouraging. This next paragraph submitted by Mr. Biswa that the petitioner is innocent and he is not at all involved in the arrest of Mr. Further, from the entire itself, it is seen that the entire allegation is brought against one driver, namely Nazirul Islam, who alleged to have converted a bitumen to water in his safe drums and fraudulently brought to origin. The present petitioner is a daily laborer. He hails from Samaguri and no way connected with the arrest of myself. But as he received notice from the police, the section 35.3 and 35.6, 35.3 and 35.6 BNSS, he held the apprehension of being arrested in the connection with this case, and hence some interim protection may be provided to the so that he can appear before the IU and can cooperate in the investigation. Mr. Botto submitted in this that if he is only a daily labor, then there may not be any reason. For his apprehension of arrest. Considering his submission under effects of the find that interim protection, some interim protection may be provided to the petitioner so that he can appear before the IU. Again. Okay, you'll be under interim protection.
Sure, I undertake me.
On 19.3,
19.
24.3, 24. 24.
May it pleases your lordship. This is an anticipatory bail application, your lordship. FIR is not known, lordship. Record may be called for.
Pardon?
I'm apprehending because Gorsuk PS is searching me,
Achha.
searching the petitioners. FIR is not yet known.
You made an inquiry in the police station. There is no FIR.
No, lordship.
From Gorchuk PS.
Yes, lordship.
You are MS?
You, sir, dearie lordship.
Part MS Surgery, the learned council. Part Supreme Court. The learned edition PP appearing on state response. This is a petition seeking anticipatory bail with an apprehension of arrest in connection with any case from Gorchuk police station. Gauhati. Next part, it is submitted MS Surgery that the present petitioners are being charged by police from Gorchuk case, and hence it has the apprehension of arrest in connection with this case, and accordingly separate for interim protection. Next part, Mr. Potter, would you learn additional PP submitted that he will take necessary steps in obtaining the detailed report from the concerned police station as to whether any case has been raised against the petitioners in connection with any case in Gorchuk case. In view of this, later detailed report we call for from Gorchuk police station, Gauhati, and the learned additional PP will take necessary steps. List when it can be.
On 12.3.
We are calling for a report from 12.
Yes, lordship.
May I please?
Yes.
Well, this is my anticipatory bail application, my lord. Earlier we have filed the anticipatory, therefore, my lord, withdraw due to my lord Sasit in the meantime file lordship. Lordship, what is there, lordship, at case number 46. Due to Sasit file, my lord, the matter become impacted, we have to accordingly withdraw. My lord, now we have again filed this application, lordship. Case number 46, my lordship order. There is a no interim. Accordingly, we file the bail application.
No, you earlier You simply withdraw the case as you have seen absconded.
Yes, yes.
Then
That
without
number-
that, thereafter you have not taken any steps.
No, my
I
lord.
mean, you have not appeared.
No, my lord. What is even, my lord? The case is pending before the, my lord, at committal stage, my lord.
Ah.
In the, my lord, Lanet CGM court. My lord, the
Yeah.
offense is triable by the, my lord, Lanet, my lord, action court. Therefore, my lord, we,
During entire period of investigation, you were absconding,
No,
you
sir.
are not cooperating and.
No, no, my lord, we are not, as only, my lord, the police did not find us, lordship. Anyway, my lord, we are now ready to, my lord, cooperate with the trial, lordship.
What to ready to now?
No, my lord, we are
For
ready to.
your cooperation, the matter would have been
No, my lord.
different. You have not cooperated.
So, yes, my lord. Absconding, my lord.
103 is also there.
Yes, yes, yes. Therefore, my lord, lordship, we are, my lord, apprehending, my lord,
What
because,
case there?
lordship, my lord. In my lord, similar case, my lord, I have found, my lord, so one
Scan
order,
this
lordship.
here.
My lord, here is all, my lord, 103 was there, my lord. The, my lord, Lanet Singh, my lord, coordinate bench, my lord, observe, my lord, very, my lord, 8 page, paragraph 9, my lord, kindly see, lordship. Same case, lordship. Only, my lord, paragraph 9. Yes, yes. Very seriousness, sir. Paragraph 9, my lord, will protect me. Lordship. I will cooperate with the trial, lordship. We've already spoke with the advocate. To let you, because my lord, only problem is, my lord, the case is, my lord, committal stage. Therefore, my lord, we could not appear. It's, my lord, 103.
See to it, what is the nature and what is the case of. Scan copy of this here along with the case date. From which place? Which
Lordship, Dhuburi.
section is Dhubri?
Lordship, my lord, at PRC case number 107/26 pending before the learned Chief Judicial Magistrate Dhuburi.
Just a second. PRC case number?
107.
PRC 107/26 pending before
Learned
GMFC.
CGM. CGM.
Learned CGM. CGM Dhubri.
Dhuburi.
Can copy of this along with it. Next date, can you tell us the next date?
Next day, my lord, I have to find yours. For 10 days.
Yes.
20.
Especially will do the date. 23 will too long for you or will okay?
20 March.
20.
Yes.
20.
Bibliography.
May I please, your lordship. Lordship, this is suspected matter, lordship. The petitioner is shown as absconded. My lord, what has happened, lordship? Let's say, FIR is at page number 12, lordship. Allegation against the petitioner is false promise to marriage, lordship. Now, what has happened? The same complainant has filed two FIR, lordship. Yeah, one is that first FIR is that page number 12, lordship, before the Nagaon, lordship. The second FIR they have filed in page 31, lordship. This was filed before the Goromari police station. Thereafter, the Goromari police station has transferred to the Bokista police station. Now, in this case, lordship, the petitioner was arrested and accordingly, he was granted bail by the Honorable High Court. Lordship, as page 41, lordship. One is the order of the Honorable Court in second FIR, lordship, before the Bokista police station, lordship. It was granted bail by the Honorable High Court. Now, what has happened, lordship? Kindly see the FIR. FIR's allegation is same, lordship. The information is also same. Now, in Nagaon police case, lordship, the IO has filed a search sheet, and thereafter, lordship, and today is the appearance before the learned JMFC Nagaon, lordship. Now,
What about second?
Second FIR, I have already granted bail, lordship.
No. Is the charge sheet is there? No.
No, that not till that no charge sheet has been filed, lordship.
Where you are saying that both the FIRs are same?
Lordship, kindly see the FIR, lordship. First, lordship, page number 12. This is the laws before the Nagaon police station, Nagaon, lordship.
In connection with this FIR, only the charge sheet is.
Yes, lordship. In this connection, we have shown that I have shown as founder, lordship. May I read, Lordship?
Who are you?
I'm
Who
Anwar
is
Hussain,
from-
Lordship.
Huh?
Anwar Hussain, Lordship. Anwar Ali, sorry. Anwar Ali. And Prohibitions has already granted bail in this connection, in this case also, Lordship.
What is the second affair?
Second offense, Lordship, page 31 is the vernacular, Lordship. Page 27, Lordship. Now, I'm ready to face the trial, Lordship. Moreover, Lordship, when I was arrested, I has not shown arrest me, Lordship, in this first affair. That's why I am not evading the arrest. Now I'm ready to face the trial, Lordship. May allow me to go and appear before the
First affair.
first affair, Lordship. In second affair, I was arrested, Lordship. Lordship, during the arrest, Lordship, I can arrest me, shown arrest, but they
That
have
was
not
not there.
not arrest, Lordship. That's why I'm ready to face the trial and allow me to.
But one was pending before Noga and other one is before
Both Lordship.
Positive.
Both is the PS, Lordship. In this connection, I have granted bail. Page 41 is the order of the Honorable High Court, Lordship.
Yes.
There in Nagaon case also, is Nagaon case. Nagaon also, initially he was granted bail, my lord.
In Noga.
Nagaon case also, my lord.
Which page?
No, Lordship, that was perhaps, I have annexed the order, Lordship.
Case number 3, my lord, paragraph number 4. Nagaon PS case number. Nagaon, the Honorable additional session, the FTC number 4, Nagaon was pleased to grant bail to the petitioner by the order dated 29/24.
Yes, Lordship, page 16. Lordship, I have annexed the order 25/9/2024. Lordship, I have verified the or record of the Honorable Court, but it was perhaps wrongly passed this order, Lordship. Page number 16.
Page number?
16, kindly see, Lordship. Malika Begum has granted bail, but our name has wrongly typed, most probably, Lordship.
Wrongly typed.
Yes, Lordship. In
What wrongly typed? Your name is there. Anwar Hussain alias
there, Lordship.
Anwar Ali.
In paragraph number 4, he has wrongly
Yes,
written
Lordship,
that
kindly
obtained
come to
bail
page.
in that Nagaon case. But from the order, now page 16, it reflects that Anwar Hussain, the present petitioner, in fact, was not granted bail. So, paragraph 4, he has wrongly written as
No,
that.
my lord, kindly come to page 26, Lordship. Page
The
26.
Honorable Additional Session Judge FTC number 4 allowed the accused persons, namely
Yes,
Anwar Hussain alias
Anwar Ali
Anwar
was
Ali
also granted.
and Malika Begum is allowed to go on bail for ₹35. So he's granted bail.
No, Lordship, I have not filed a bail petition, Lordship. Now kindly come to page 26.
So
Lordship.
you see the order.
Yes, I have seen the Lordship. I have verified the order.
Kindly pass over for the time being, Miller.
Lordship, kindly
After
page
some time.
26, accused person, namely Malika Begum's court bail and Mohammad Anwar Ali is shown as absconder, Lordship. I am Anwar Ali, Lordship. In
But
page
you-
26, I have annexed the subsequent order, Lordship.
You are granted bail.
No, Lordship, I have not granted bail.
Why court will pass such kind of order then? In page 16, you are.
Yes, Lordship, 25/9/2024, Lordship.
Ah, yes.
That was the order, Lordship. Again, 24/6/2005, Lordship, kindly come to page 26, Annexer D, Lordship. I have annexed the order of the Honorable Court, Lordship. This order I have shown as absconder, Lordship. To page 26.
So probably after obtaining bail.
Page 26.
It is clear, isn't that you were on bail? You are on bail.
But Lordship, can you call for the record, Lordship?
You have furnished the charge sheet also here?
Lordship?
Copy of the charge sheet is also here?
Yes, Lordship.
Which page?
Page 21 onwards, Lordship.
21.
Status of accused shown as absconder.
Page 24 is the relevant part.
Obtaining bail from the court, you have not appeared before the IO. There must be something. Otherwise, how you'll show an absconder?
Lordship may call for the case
The
record.
bail bond, you have not
Yes,
furnished the
yes,
bail bond
yes.
before the police.
Usually, as per my client instruction, they have not filed a bail petition. Malika Begum has filed this petition.
The clear order of bail is there only.
But by that order, my lord, he was also granted bail. my
Ah, by that same order, one Malika and you,
lord. Yes.
both of you are granted bail. Call for the case diary, case record. Otherwise, if you are already on bail,
Yes,
Yes.
you should not be shown as an absconder. That is the reason, one reason.
yes.
Another reason may be, most probably after
Yes.
obtaining the bail, you have not furnished the bail, copy of the bail bond, etc.
Actually, by submitting an application before the trial court, if he points out that order, my lord, he will definitely on that day will get
Yes.
bail. my lord. New order.
Yes, sir. 4%. It has to come from which court now?
Nagaon, Judicial Magistrate First Class.
GMFC now. Okay, PRC case number
486/25.
486.
Yes.
486 of 2020 GMFC. No. PSTP. Next date, can you tell us?
On my lord,
Today is the
Oh, today was the date.
24th of
obliged.
The petition is a submission of CRPF posting at Manipur and following on situation. For the case is what? The personal relationship becomes sore. There is a relation between the informant and the petitioner. The FIR is at page 49. Earlier various FIR was given and complaint was given, and this FIR was filed, complaint was filed before the National Commission on Women, Delhi, and is forwarded to the Rohtak police station. A 05 was lost, and thereafter this FIR was registered. Page 49. And the portion is page 50. I, Manasa Sunwal, resident of Ron Lakhimpur, Assam, want to file a serious complaint against a man named Vinay Kaur. He was a CRF earlier, now he is not. His home address is Haryana, Rohtak, Baniani. Earlier, I had submitted a complaint to NCW, but it got rejected. But because I hadn't provided all the details at that time, so now I'm submitting it again with a full and complete truth. Vinay and I first became acquainted on Instagram. He had first sent me to a request around June-July 24. Then we became good friends, and our conversation continued well. On October 25th, it was his POP, means, passing of period. So he invited me to his POP. But that time I did not know him properly, so I did not go. Then he got posted in Namsai Onusal. So he called me to Onusal Pradesh to meet him. But I was afraid of the people of Onusal. So I did not go there and cancelled the meeting again. Then suddenly on November 13th, in the evening, he called me and asked me to meet on 15th. I refused because I had an exam on the 15th. Then he emotionally blackmailed me a lot, due to which, in anger, I agreed to go there. On 14/11/24, I left my home for Gauhati. From Lakhimpur, he came to Gauhati. Then on 15/11/24, I reached there. He was already there. Then both of us started searching for a hotel. Then a rickshaw driver found us a hotel which was in Ulubari, under Ulubari overbridge, named Hotel Kalani. After keeping our luggage there, we went towards Kamakhya temple. Then in the evening, we went to City Center Mall. Then at night, he proposed to me and also said yes. And also I said yes. And we moved our relationship forward. The next morning, I was checking his phone. Then again and again, a girl named Isa's SMS was coming. When I was asking, he said she was a friend, but he was talking very wrongly with her. So I fought with him. Then he tried to raise his hand on me. I started crying. So he did not hit me and started explaining to me. Then in the evening, he had a train from Kamakhya, but he missed the train. So we stayed at the station. Then he got another train and went to his home and also returned to my home. After 3-4 days, he proposed marriage to me. Then our conversation was going well. Then he gave me his Instagram password. When I checked, we now talk very dirty with girls. So we had a big fight on this. Then again, it has SMS came. So I abused him and warned him not to talk because of his Vinod became very angry and did not talk to me for 2 days. After 2 days, we started talking again. And on 7 December, he told me that his father had found another girl for him. I fought on this matter. Then he said the girl's father is giving good dowry, so his father agreed. He said, if you had also arranged dowry, then tell me. I want to talk to my father. I said, from where I will bring so much money? I don't even have parents, so who will give me money? He said, if you cannot give dowry, then forget me. I cried a lot. Then he said, let's meet and talk. Then he came to meet me in Dibrugarh and also went from Lakhimpur to Dibrugarh. After going there, we both sat in Jagannath Temple Park and started talking. While talking, it became evening. It was Sunday, so we are not getting any pass. But I called a brother who studies in Dibrugarh.
FIR.
Huh? This is FIR. 9-page FIR.
Huh?
Lots of allegations.
Lots of allegations.
After my departmental inquiry also held against the present accused. Initially, my lord, he was terminated. Thereafter, my lord,
reinstated.
finding no, he was again reinstated, my lord. Then, my lord,
She
at
came
this
to
stage,
Manipur.
lots
Then
of
she came to
allegations.
Haryana. The
At this
girl.
stage, my lord, he may be allowed to record his statement and my CD may be called for.
When I was a JMFC once, and the CGM just asked me to record a statement of a girl, victim girl,
Yeah.
under 164, earlier ones. Case was under 498A.
Yes.
So I just asked what had happened. She explained everything, when they met her, when they got married, how they were going here and there, what was the good relation. Then I stopped talking.
Yes.
Don't talk all this stuff. When he started beating you, just tell me that.
Yes.
These things are there. He's switching from here to here, one Gauhati, one Arunachal Pradesh, wherever. But anyway, let him go appear there.
Let me record his statement.
9 pages FIR.
9 pages second.
You are Mr. Gogoi?
SR Gogoi.
Or Mr. S.R. Gogoi, the kind of petition. The submission made by Mr. Gogoi and Mr. Gogoi, and considering the submission made by Rhino Council and also considering the matrix available in the statement made in the FI. We find that interim protection may be provided to the representative so that he can appear before the eye and can cooperate with the investigation. In view of this, it is to execute in this case. Yes, for and it can be.
On my lord, 25th of March.
Will be some under interim protection appear before the IO within 7 days and cooperate in the
10 days will be serving at Manipur, law and order duty,
We want
fighting
10
with
days.
insurgents.
10 days within 10.
Obliged.
May please, Lordship. Here in this case, your Lordships, I am praying for anticipatory bail to petitioner, that is Abed Ali and Shahidur Rahman. What is happened, your Lordships? One of informant Monoranjan Kolita lodges an FIR before Ramdia outpost under Hazu police station, alleging that some unknown miscreants theft of one of cow from his farm using a black Scorpio vehicle. So we find FIR Lordship 9, Annexure 1, the FIR made today early morning at about such and such am, some unknown miscreants entered into my house premises using black Scorpio vehicle bearing such and such number and another white Scorpio vehicle and started to loading 2 cows from my farm into the aforesaid vehicle. Thereafter, I hearing the noise, I step outside the house, started to swimming. In this regard, they left 1 cow and loaded another cow and fled away on high speed. This is the FIR. FIR registered on your Lordships under section 3, subclause 5/305, subclause A and 331, subclause 4, BNS, your Lordship. Accordingly, during investigation, page number is C16. During investigation, 3 accused persons were arrested, one of Ramzan Ali and one Zakir Ali and Sonabur Ali. Zakir Ali and Sonabur Ali, both the father's name was Shahidur Rahman, who is the present petitioner, petition number 2 in this case. So accordingly, they were approached before the Alakam estate and accordingly they are released on bail. And after, and their Lordships, and cattle owner was approached before the Alakam estate and accordingly they are filed one Jimma petition and Lordships that seized cattle was released to the owner, your Lordships. And you turn to the page 17. Why I am apprehending? Point number 6, ground of arrest. During investigation, evidence found that the Shahidul Rahman, father of the arrested accused person Zakir Ali and Sonabur Ali. In this case, petition number 2. And Shahidul Rahman is the father of the Zakir Ali and Sonabur Ali. They are released on bail. And another absconding person, Abedur Rahman of Lohargatha, Nalbari, are also involved in this instant case, theft case. That is the petition number 1. Why I am apprehending, your Lordships? Petition number 1, actually, he had a list on pond nearby the house of the petition number 2. And on that day, he went there and parked one vehicle, that is Bajaj on Pulsar, in the courtyard of petition number 2. And at the moment, police came and arrested the accused person, that is Zakir Ali and Sonabur Ali, who is the son of petition number 2. And also, that is why I am approaching your Lordships for anticipatory bail. And another fact is that the petition number 2 is the father of the Zakir Ali and Sonabur Ali, who is a release on bail that I have submitting the order. So he had purchased one cattle from arrested one accused person, that is Ramzan Ali. He doesn't know whether this cattle is theft cattle or not. So only allegation is purchased. And accordingly, your Lordships, accordingly, he was apprehending. So in this case, The seized vehicle already been released on Jimma, and other co-accused person has already been released on regular bail. In this case, police is charging. So in the meantime, I am cooperating the investigation authority. Any condition may be imposed. Interim may be protected, Your Lordship.
Otherwise, my lord, during investigation after arresting of the all other accused persons in the from the ground number 6 of the other arrested accused person, my lord, it seems that they are also involved in the offense, my lord. How they are involved only CD will reveal, my lord, and what are the materials only.
6 accused person already been released on your bail, Your Lordship. I am submitting the bail order as well as seized cow also released on Jimma to the owner. So any condition may be imposed.
Those are BA, my lord.
Time appeared before the IO. Also have not FINM accused person. So and seized cattle was recovered, also released on Jimma.
The part is also near the one of the it is searching for which it is submitted petition number 2 state part of arrested accused persons. His petition against him had been cow from one of the arrested on video footage. The vehicle as well as the cattle already been covered by the however, is but what the from the forwarding report of the other person, it is mentioned that these two petitions also involve a state call for the case is yes the some interpretation may be given to the petition. Be under interim protection.
Lordship.
You will be under interim protection.
Yeah.
7 days you appear before the IO and cooperate.
Lordship.
27-3.
27.
Yes.
Obliged.
Proceedings for it to BNSS application for anticipatory bail in connection with offense ER number 03 of 2024 into forest.
I will have to special PP mal forest. I will have to inform forest.
What time?
Go go. Fix it.
Google.
Port number 5.
Plus, me can take up after some time.
For some time, yeah.
May it pleases your lordship. My lord, what had happened in this case, my lord? The present petitioner are the father and the brother of a person called as Saurabh Kumar, who had, my lord, some business relation with an ex-politician from the state of Arunachal Pradesh, namely T.L. Rajkumar. Now, my lord, since 2019, the Saurabh Kumar, that's the son of the petitioner number 1 and the brother of the petitioner number 2, he has been staying separately with his wife. They are not staying together. Now, my lord, suddenly in 2025, December 2025, this T.L. Rajkumar comes to the house of the present petitioner and says that he has paid certain money to Saurabh Kumar for purchase of certain flats, and Saurabh Kumar is absconding. And he said that if you do not find Saurabh Kumar, then I will get both of you arrested. The same threatening was again repeated in the month of January, my lord, which I have mentioned in my para 4 and para 5. I've given all these details, my lord. Para 3, para 4, and para 5. Now, my lord, we are not sure whether any FIR has been lodged or not, my lord. Let them produce a report, my lord. And moreover, the petitioner number 1 is a retired school teacher. Let them obtain a report from Jalukbari police station whether this TL Rajkumar have lodged any FIR implicating these present petitioners or not. Until then, at least no coercive action may be taken against us, because it is a purely monetary deal between the son. That is why, my lord, in my prayer, I have specifically mentioned that. With respect to non-refund of money paid to Saurabh Kumar, that is the son. Because he is a powerful man, my lord. At any point of time, an FIR may get registered, and we know, my lord, how the police works, man.
Yeah,
And a
this
report
case, any short date may be fixed, but I will get a report first, man.
Report. This application. Yeah. Connection with case to be raised under judgment. Subject after whisper that these two petitioners are father and brother of in these petitions are father and brother of one Saurabh, respectively, who had some monetary transactions with one TL. But on December 2005, in month of January also, they said TL Kumar visited to their house in search of said Saurabh Kumar, who some and project against these two. The receipt of it, they be provided with some about who they report the station, the raise objection, providing any during this mission, and say that the date report from Jalukbari police station, where case has been raised against these two petitioners in the said police station. And police station in the meantime, the police from Jalukbari place is hereby directed not to take any course action against the present petition.
I'm so deeply obliged.
Against what of anything
My lord, on 13/3. No, 13/3, man.
I'm deeply obliged.
Kindly fix this matter after some time. My senior has not arrived.
May the lordship is a previous bill application filed at page 11, the main FIR at page 15. Lordship. It was originally a complaint application, which was later on registered as a FIR. So, Your Honor, my name appeared in page 15, Your Honor. 2, accused number 2. I am the principal of Dispur English Academy. And that Binoy Mishra is one of my ex-teacher. And next to the next page, Your Honor, Lordship, para 2. Para 2. The accused number 1 is the ex-teacher of Dispur English Academy, and accused number 2 is the present principal of the same school. Both are the so-and-so, so-and-so. That allegation against that accused number 1 and me against that we have taken money from the informant in the name of admission, and we issued a fake certificate of examination. Your Honor, I like to draw your lordship attention on the page number 20.
Fake certificate of examination.
SSLC.
Fake. SSLC.
Certificate
Fake
of which
certificate.
is
Mark sheet.
Mark sheet. Fake certificate.
Fake mark sheet.
This is the allegation, lordship. So I'm referring page 20 of the application. Yes, this cause of action referred as 4/11/21 and 8/1/22. It's a very old matter, lordship. And however,
So now at present, this complaint was filed on when? On 25.
complaint on 23,
Complaint was filed on 23.
23, 26/7/23,
23.
23. And later on, it was registered as an FIR. So police has issued 35 BNSS notice, page 23, that copy at page 22, against me, and as well as my wife also, that's it. So I have preferred a anticipatory bail application before the Honorable Session Court, and Session Court has granted bail to my wife, and my application was rejected, that investigation is not completed, so and so. I'm annexing that order, page 26, Annexer C. So this is the allegation, Lordship. Lordship, I am the principal of the school, and I have specifically mentioned in para 6 of my bail application that I have never authorized that Binoy Misra to take money on behalf of my, or I have never issued any SSLC pass certificate. So if Binoy Misra
This is your submission. I can understand. You may not issue or may not instruct the other person also. Very serious case. Yes, bottom.
Yes, my lord. Although cases registered in the year 2023, bail petition of the present petitioner was rejected on 25/2/26, my lord. At that point of time, petitioner and one other, Aparna Sinha, has filed anticipatory bail application before the trial court, my lord. And that was rejected by order dated 25/2/20.
Rejected on the petitioners only.
Allegation is otherwise, well, but from the earlier order of the learned trial court, it seems that there is some lapse of the investigation is there. But my lord, regarding allegation is serious, posing of my lord mark sheet, and thereafter my lord taking admission all these allegations.
And I'm ready to cooperate. I'm the principal. If I am arrested, that
if you
Lordship.
issue very such kind of fake matriculation certificate, it's a very serious kind.
Serious. The allegation is serious, Lordship. That is why I'm ready to cooperate the prosecution.
So if you cooperate also, let us call for the case.
Yeah. So he is the principal, so interim protection may be given.
Principal, I can understand he is a principal, being a principal. If he
Because now it is examination of, yes.
Kind of
Yes, examination is going on, Lordship.
what will be the fate of a students on the principals? Yeah. It has to come from this
Dispur.
Dispur. We are providing a short date.
Yes, on 11/3, 10/3.
10. Very short date we are giving. Hopefully we'll get.
70.
Petition of
Extra copy to nine, my repeat report I have a translation.
Any
As per the last order, my lord, one report was to be.
Yes.
Apart from that, my lord, today I come to another interesting point. There is a report of commissioner. My matter is relating to a case record went missing since 2019, filed by the petitioner. I am the complainant cum petitioner.
Yes.
And in the year 2019, I filed one FIR before the All Women Police Station. Thereafter, I have been told them that the matter would be proceeded and you would be receive summons from court for witness. So
5 years passed. In the year 2025, that petitioner complainant visited me personally, and I inquired before initially I inquired before the CJM to see what is the proceeding or what is the progress. Then I come to know that there is nothing, not a single paper before the Magistrate Court Kamrup Metro. Not even a single entry was there. So I visited the second OC, Oloman Police Station, and I came to know that the record has been in the year 2020 transferred to Badarpur PSK. So that was not known to me, not known to the complainant, for which I filed this petition, my lord. So there, after filing of this petition, on the instance of this honorable court, some investigation and inquiry was there, and the matter was forwarded to the Commissioner of Police for inquiry about the whereabouts of that case, my lord. So the present OC as well as the earlier IO stated there before the commissioner, that report is there, my lord. Kindly come to page number 4 of that report, my lord, commissioner report.
You have submitted, I can understand that. though it
Just
was
I want to
transferred
highlight
Badarpur.
one point, my lord. There, one sentence is there stated by that IO that I personally went to Badarpur, and prior to that statement is there that I have been directed to approach the SDGM court, Kamrup Metro, for transfer. So she was the IO. How come she was directed to approach the SDGM for transfer first? Second,
No, but you have submitted on that day that though it was transferred to Badarpur, but Badarpur there is no case record.
Yes.
Or neither there is any record of transfer of the case to Badarpur also.
Yeah. So as per the earlier order, my lord, it is written that there should be 3 triplicate files. First,
Yes, obviously.
yeah. So as per the last order, it was to be if there any record before the circle officer. But the thing is that
in this case, I have communicated through a letter, lordship. The order copy has also been sent to the Commissioner of Police, but till now I have not received any reply to that, lordship. May kindly give some more time, lordship. I will again communicate to them, lord. I have communicated it through letter to the Commissioner of Police whether any record is available or not. I was asking.
But as per you, is there any probability of reconstructions of the file?
my lord, first thing is that at that time medical.
With you, the copy of FIR is still with you.
Yes.
That is with you.
Well,
And otherwise, to do
but
something for reconstruction.
but the problem is
But I have the information, lordship, that the order for reconstruction is there from the higher authorities to this IO, lordship, and she was trying to reconstruct.
But in the reconstruction, there might be 2 problems. First thing, that at that time medical things were there, documents, prescriptions were there. How could the present IO or OC could get those documents? First of all. Second of all, my lord.
If you don't get anything, suppose, but at least after reconstruction, we file the proceeding for the recording of your statement of the witnesses, etc. may be in progress. Otherwise,
That benefit would be taken by the accused person,
then,
because
then what do you suggest?
well,
What do you want?
that is why earlier this honorable court passed that order to trace out the whereabouts. First of all, triplicate file should be there. Till now, or even after 4 or 5 days, the commissioner is
Last
taking
time
lightly.
we have received the report.
Yes.
Probably the files are not there. They have put all the blames to that Parliament police station who was in OC in charge, or the IO. All every blame was put on her only. But now the question is, their record is not maintained neither in 3 places where it has to be triplicate file.
But
it's not there.
Circle officer was not traced out. That is why last order was there.
Yes, in
Yes.
circle office, if anything is there.
If anything, that would be.
Now you
I have communicated.
instruction as to whether the circle office, is there any kind of report,
I have
any
lots.
kind of
I
thing
have
is there,
communicated lot.
so that it may help, it may help in reconstructing the file.
Yes.
That may also be one of
Because
it.
some documents might
I have
must not be there.
communicated to it, but I need some time, lordship, because they are also looking for it. I have given it to the PP office, lordship.
the Commissioner of Police.
Then when it can be fixed as per you?
Lordship. On March 24, Lordship. March 24, 27, Lordship. In the meantime, I will also communicate telephonically.
Will it
My
be
lord.
fixed or not for you?
My lord, in the meantime, may I pray, because if we see the whole matter from inception till now, it is clear that the involvement of the accused is there. Because recently I approached the railway because he is the railway officer and filed one RTI. No record was furnished. Thereafter, I made one appeal. Now, day before yesterday, 17th, my lord, seems to be 17, but I have received day before yesterday. As per this, my lord, kindly come to page number 2, serial number 9. Other information they have been denied to provide me, saying that it is a third-party information. So railway is also not trying to give me any information, my lord. Although it is not directly relating to this case, but the thing is this, my lord, the involvement of the petition accused is clearly, my lord, visible. Kindly come to page, serial number 9. The words are very important. Item number 9 to 11, departmental proceedings were initiated in accordance with railway service law. Were initiated. In the year 2019, he was arrested. Now in the year 2026, the railway department has been saying that departmental proceedings were initiated, whereas I have clearly asked them what was the departmental proceeding status, or whether any disciplinary action had been taken against the accused or not. Nothing has been. Were initiated. Were initiated means in the year 2019. As because the record could not be traced out, or no record was found, or it seems that no case is pending against that accused, because if we search before the Oloman police station, no record is there because it was already transferred. Even anything was there, it seems to be shown as disposed of, being transferred. And Borderpur police case, there is no record also. So railway also not, my lord, taking any action against him. So involvement of the accused is visible, my lord. So may I pray at this instance, my lord, notice may be issued to the accused too. First of all,
from this court,
my lord, because he is the party. I have made him party. Till now, I never approached before this honorable court to send notice to him. But since 2025, after so many inquiry reports, where the police has also admitted their guilt, my lord. Now the railway has been also saying that departmental proceedings were initiated. But they are not saying that we have taken this punishment against the accused. So accused being a railway officer and having a good background, it is clearly seems, my lord, he is involved. The matter is pending since 2025 to 26. I never approached before this court to issue notice, because I also know that the things had been, my lord, done by the police, because record was misplaced. But that commissioner's report, as well as the Borderpool police case report, the magistrate court record is also not there, my lord. Not a single entry is there. Now the railway is also saying that only proceedings were initiated. So earlier direction, my lord, my friend has already.
prayer is quite a bit different prayer. So against the accused, though you have made him as a party respondent number 4.
My lord.
But what will be the purpose of issuing notice against him? Because if you go by your prayer, you see at the premises so and so, issue notices so and so. So as to why the honorable court should not exercise the inherent power and issue proper direction to respondent authority to deed in full case earlier registered so and so. So this kind of things particularly against the present accused, or you have named as an accused, whatever, it's not there anything. Is there?
I would be grateful if the matter is in, at the first instance, the record was found and direction was given by this honorable court to the police saying that you do your part. But after elapsing 1.5 years since 2025,
Petitioner, we are not in a position to say whether anything is there or not. You have brought some allegation.
but
Is that there?
my lord, I have
And
not
I-
brought anything, my lord.
No, whatever, as per you, he may be the accused, or there may be some allegations against him.
He is behind bars, my lord, for 30 days.
Whatever is there. But in the present petition, there's no kind of prayer against the present accused.
But the thing is that the police has done things which would directly benefit to the accused. And he is getting the benefit, my lord. I am suffering. For last 6 years, since 2019 to since 2000 till now, my lord, the benefit has been given to the accused by the police. I must
We'll
allege.
give some time to the prosecution to get the report.
Right.
You are saying when?
27 March.
27th of March. Hard Mr. Deacon. Hard Mr. Ekeda is submitted by Mr. Das that he had some telephonic conversation with the IO, but he could not. The IO could not provide any report, which was called for the last date of. Accordingly, he submitted. He needs some more time to take instructions, and in view of the order dated 17/2, in view of this later detailed report be called for, and detailed report as well as the instruction be called for from the concerned to as from the authority concerned regarding the reconstruction whether any steps has been taken for reconstruction, as well as whether any record is maintained in the circle office. The learned petitioner PP is hereby asked to take instructions as well as the report from the concerned authority on the incident. This demand accordingly on 27.
Right.
So listing it on 2070, Mr. Nath, let us see. If it's not there, then definitely something has to be.
Public.
Whether they wanted to file some rejoinder.
Basically, your lordship, I'm in 19, my learned senior friend is in 20. It's basically on the same facts and circumstances. We have come for quashing of the case, your lordship. And the issue was with regard to a loan amount fraudulently taken. And now we have already repaid the whole amount. Everything has been done. This is the reason we have come. And there is also that some persons have already not been brought into this net of your lordship. They are on the similar. So there is also a parity part also there. These parts were, and now since they have filed an objection, bringing in certain specific things which we have to, your lordship, counter by an affidavit. That is why we'd like to take some time, at least 2 weeks time.
You are for the other side. I am for the. You are for the railway.
It's a railway of employees here. All are railway.
It's with regard to housing loan.
It's a housing loan. It's a housing loan.
Advances to the employee of the railway. So some of them have paid. That means it is an admitted offense. And some of them probably not yet paid.
My clients have paid. They have completed all
Basically,
the whole.
dispute is civilness, not criminal. Nothing has been left now.
But
Money has been paid
Your
back.
lordship, we'd like to file.
Manufactured. Documents are manufactured.
That is not done by these persons. We have availed the only loan unit. The company who has done it is a different person. Anyway, that will bring it on. No, Aji, we're hearing lordship will give us 2 weeks.
In item number 19.
19 and 20.
I appear in 19.
You
My
are
learned senior is appearing in 20.
Your name is not showing here? Mr. Abdullah's name.
He has requested me to appear in.
Oh, anyway. Let us say 19, 20. in a- You are assisted by whom?
As Sutradhara.
As Sut- Mr. R.P. You are Mr.
No, no.
Take the and consider it. And government of J Assam is also there, or
Titular party.
not it, not it.
The railway and the CBI.
19, 20 commission submitted that's and it required by against the no, the CBI. Prayer about. You want any fixed date here or after 2 weeks will do?
Let me fix after 2 weeks. Meanwhile, we shall file the affidavit.
Now, after 2 weeks, you want a fixed date or after 2 weeks? You want a fixed date here?
And the lordship, please, within 2 weeks, we shall file our affidavit.
After
Day
2
after.
weeks, your lordship, let it be.
In that case, 30th of March, 30.
Lordship.
Lordship.
30 March.
Lordship.
Much obliged.
Separate order. You take a order.
Applied.
Thank you, madam. Along with item number 41.
My lord, CD was called for, possibly it is received.
21,
Hello.
10,
My lord, item number, all are BA, my lord, except item number 24 and 27 AB, my lord.
except item number 27.
24 and 27 AB, my lord.
20.
Lordship, here, what happened, Lordship, regarding item 38, Lordship, in this case, Lordship, AB, he is arrested. Lordship. Item 38, so it's become infractuous.
So, my lord,
Item
Item 38, Lordship,
38.
yes,
Actually, he is already arrested.
already. So it's become
It
infractuous.
has become infractuous.
I'm representing, Lordship, item 38, Lordship. So far, I'm representing 21 to 29, but suddenly, Lordship, 21, the file of 21, item number 21, Lordship, has taken over from me, Lordship, and they have engaged senior counsel, Lordship.
Now, Mr. Sheikh is appearing in other matters.
I'm 22 to 28, 29, I'm appearing, Lordship. And also
Just a
41.
second, you are appearing on 38. You have submitted. He has already got arrested, so it
Yes.
become infractuous.
Yes.
It is disposed of. And another which matter you are appearing?
From 22 to 29.
20. You are appearing 22
Yes,
to
Lordship.
29. Achha.
22 to 29 and 41 also, Lordship, supplementary.
22. And Mr. Sheikh is appearing in which way? Which?
Only
20, only 21.
You are appearing only 21. And
Right.
rest 22 to 28. You are appearing.
Yes.
And another matter 41.
41.
41 also you are appearing.
Yes.
Yes, we have received the case diary.
Case they received, my lord.
My lord, now your lordship would be, first thing is this, my lord, I am on interim bail.
In which item? Item number 21.
21. 3 petitioners, my lord, Guljar, Fakrul and Nazrul. They are on interim bail. That order may be looked into, my lord, on 21/2026. We are granted interim bail by your lordship. Now your lordship would be pleased to turn to page 19, my lord. The FIR.
Yes.
My lord, I am reading the vernacular, my lord. মাননীয় বিপুরিয়া থানার ভারপ্রাপ্ত বিষয়া মহোদয়, ডেট ইজ 28/12/2023. প্রসঙ্গ বাগলামারা চৌকির দৈনিক দরজ নম্বর সোয়েন্সো ডেটেড 27/12/2025. আসামি Baharul Islam, etc. My lord, here my first submission before your lordship 8, 9, 10. 10 person has been named. But my petitioners, my lord, Guljar Hussain, Fakhruddin Ahmed, and Mohammad Noor Hussain, are not named among these 10 accused persons.
I am not named accused. মহোদয়, সম্মানপূর্বক বিবিধ নিবেদন এই যে ইংরাজি 27/12/25 তাৰিখে সন্ধিয়া 6:10 মানত বিহপুৰীয়া থানাৰ গোচৰ নম্বৰ 79 of 2000 সংক্ৰান্তে থানাৰ ভাৰপ্ৰাপ্ত বিষয়া মহোদয়ে মোকৰ্দমাৰ লগত জড়িত থকা পদকীয়া মহম্মদ বাহাৰুল ইছলাম এলিয়াছ আম্বানী কৰায়ত্ব কৰিবৰ বাবে নিৰ্দেশ দিয়াত Here, my lord, I want to take a pause. This Baharul Islam, my lord, already arrested on 1/3/2026 and he is in judicial custody. Baharul Islam Ambani Koratto Koribor Nirdek Diat Moi Aru Hongio 13 AP Battalion Estab Ho Mor Podokia Koratto Koribor Babe Ohamorik Posak Ho. Here your lordship will consider this ahamorik posak because they were in civil dress. They would not recognize that they are police. Ekhon byaktigoto bahon. Another thing is this, my lord, not police vehicle. Vehicle was personal one. Hafizur Rahmanok logot loi podukia jonok koraitto korar babe Romjan Tiliarit উপস্থিত হই পদকীয়া জনক রমজান আলীর এখন কাপড়ৰ দোকানৰ সন্মুখত উপস্থিত হৈ পদকীয়া জনক পাই কৰায়ত্ব কৰা হয় লগে লগে পদকীয়াজনে চিঞৰ বাখৰ কৰাৰ লগতে নানান অশ্লীল ভাষাতে আৰক্ষীক গালি গালাজ পাৰাৰ লগে লগে নকল হন আৰু নকল টকা বনোৱা এটা বিহিত চক্ৰ আহি আমাক প্ৰাণে মাৰাৰ উদ্দেশ্যে চকা অস্ত্ৰেৰে আক্ৰমণ কৰি আমাক গুৰুতৰ জখম কৰে আৰু পদকীয়াজনক আমাৰ পৰা জোৰ কৰি কাঢ়ি লৈ যায় আৰু লগে লগে আমি নিয়া ব্যক্তিগত বাহনখনৰ চালকক গাড়ীৰ ভিতৰতে আসামীখনে মাৰপিট কৰি গুৰুতৰ জখম আৰু গাড়ীখনৰ ক্ষতিসাধন কৰে So my lord, occurrence in certain Tiniali, my lord. There is daily evening, there is a gathering of people, there is market. So what happened, my lord? In a cloth shop, some persons, when they are captured somebody, immediately there is hue and cry and public gathered there. Crowd gathered there and they do not know that this is the police arresting somebody. If police arrested Baharul, my lord, immediately, my lord, that Baharul would not raise hue and cry. The police arrested me. But in the clothes shop, my lord, when some civilian person captured somebody, there is hue and cry. And public gathered there. And ultimately, Baharul was fled away. And thereafter, my lord, what happened? This case has been registered. Now, your lordship would be pleased to see the sections under which sections they are arrested, my lord. They are arrested, all the most of the sections, my lord, included. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 sections incorporated. So, my lord, my humble submission before your lordship, my clients were not present there, my lord. Not present, he is not named. And another thing is, my lord, Guljar Hussain, that is Fakurul Islam, my lord. He is a Gambura, my lord. He resides about 3 kilometers away, my lord. My accused person. And in the night, the police went there and arrested. This is the position, my lord. We are not involved in the case. And it is the police, my lord. It is the police, so-called police, my lord, in civil dress, created this nuisance. They should not go to arrest somebody in civil dress, that also with private vehicle. What is the business, my lord? They should not go. And they are responsible to create this scene. And now, my lord, as a whole, the 10%, 15% has been arrested. They are detained, my lord. So, my lord, my humble submission before your lordship, no case is made out against us. We are not present there, my lord. And it is the fault of the police, and now they are harassing the public as a whole. That is my humble submission, my lord, and CD will come. And another thing is this, my lord. CD will reveal, my lord, your lordship will look into. My humble submission before your lordship,
except one accused, my lord, regarding other two accused persons, my lord. Section 48 not complied with, my lord. That will be revealed from the CD, my lord. Whether that notice under 48, which is compulsory, is given to the relatives of the accused person. That your lordship will look in. And after going through the CD, my lord, I am on, we are all already on interim bail, my lord. Your lordship can consider.
So both is
Yes.
here together or?
Yes, my lord. I will just point out, my lord, here regarding item number in the matters which are the petitioners are in interim, my lord. Item number 21. There are three petitioners, my lord. They are already in interim, my lord. They were arrested on, my lord, 30/12/2025 and interim granted on 21/26. Item number 21 in interim, 22 in interim, and
Just a second.
23
Here
in
22
interim, my lord.
is an interim.
Yes, my lord.
22 is also interim.
21, 22, 23, although BA, my lord, all are in interim, my lord. 24 also interim, up to 25, all are in interim, my lord.
Except 41 lordship, all are in interim lordship.
Up to 25, why up to 20? But what about 26? 26 is not on.
26 interim assembly.
26 lordship. Yes, lordship, 26 also on interim lordship.
26, 27,
All are in interim lordship,
Yes.
except supplementary item 41.
All are BA, my lord, except, my lord, two items, item number 24 and, my lord, 27 AB, my lord, 24 and 27 AB.
What is 41?
41, no interim is there. It's a regular
AB,
bail.
AB.
No, lordship, regular bail lordship.
Abu Hanifa, my lord.
It's a regular bail lordship. Abu Hanifa was arrested lordship. May I please? On 12/2/2026 lordship.
My lord, in this case, I have received the case diary, my lord. From the case diary, my lord, it reflects that yes, on that day, my lord, why they were in police not in police uniform. They specifically mentioned that to maintain their secrecy, and because the accused persons situated in a place, my lord, where it is at all point of time, whenever police went there, they initially before that they got the information, and my lord, and for that, my lord, they to maintain their secrecy, my lord, and to avoid exposure, they went there in civil dress, my lord. That is there in their report, my lord. And, my lord, regarding the present one accused person, my lord, Baharul Islam, who was now arrested, my lord, as pointed out by.
Yes, Baharul arrested.
He is involved in three cases, my lord. In Vipuria PS case number 4824, 4024, and 393, 2016. And on the day of the incident, police went there to arrest Baharul Islam. Then all these accused persons gathered, my lord. Then, my lord, vandalized the police vehicle, my lord, attacked police personnel, and driver of the, my lord, police one. That vehicle was also injured. His injury report is also available, my lord. And from that injury report, that injury is, my lord, simple injury by blunt object. Anyway, my lord, injury is there, my lord. And otherwise, my lord, all these accused person helped the person, my lord, Baharul Islam, at that point of time to escape, to flee away from the place of the occurrence, and thereafter police failed to arrest Baharul Islam, my lord. And now, my lord, only on 1/3 that accused person Baharul Islam was arrested. So from video footage, my lord, statement of the 8 person, although initially, my lord, total 10 persons was FIR named, my lord. Later on during investigation, name of the other persons also, my lord, reflect from the statement of the other witnesses, my lord, their name came out, and police thereafter, my lord, arrested some of the accused persons. And regarding now, my lord, bail of the detailed report of the IO I have received, my lord, and from the materials available on record, all these accused persons are involved, my lord, already in considering the, my lord, although they are in interim in some cases, my lord, the type of offense which they have committed, my lord, is, my lord, very serious, my lord. They in fact involved in, my lord, attacking police personnel, vandalizing police vehicle, and thereafter, my lord, helping one of the accused, Baharul Islam, to flee away from the place, from that place, my lord. And now regarding, my lord, other some of the accused persons who are in interim, my lord, in AB, yes, although their statement is there, my lord, regarding BA, although, my lord, these accused person already in jail for, my lord, more than about 30 days. So considering that aspect, my lord, regarding length of detention, I would like to leave it to your lordship, my lord. Regarding AB, my lord, those AB item number 24 and 27, my lord, there are materials. Those AB, my lord, I have objection. Anticipatory bail.
Regarding 24 and 27, they are interim lordship, they are cooperating with the investigation lordship. Now things is that the Baharul Islam, whom the police,
Although cooperating, my lord.
yes,
type
the
of offense-
cooperating lordship, because of the condition of the bail is there to cooperate with the investigation lordship. That part is not violated by this petitioner lordship, all this petitioner lordship. So far, police come to arrest this Baharul Islam lordship. He is the person lordship who created hue and cried lordship. For which lordship? He said, since the person who has come to pick up this Baharul Islam, they are in civil dress lordship. He suspect lordship, it might be a lordship kidnapping lordship. He raised a hue and cry lordship. The other people lordship, there was a cricket match is going on lordship. When such type of lordship, even client shouted lordship, then they come their lordship. They are not in other intention lordship. They have not even lordship known that those who are those person lordship. It is because of the all incident happened because of this Baharul Islam lordship. He make an hue and cry lordship. That's why other people rush to this place and rescue. In the meantime, he taking that chance lordship. He escaped from the police custody lordship. So far, lordship, interim lordship, they are cooperating lordship. They are not violating any of the conditions so far imposed by this court lordship. They are cooperating with the investigation laws. And it is not the case lordship, custodial integration is required because of certain things is happen on certain moment lordship. Thereafter lordship, no lordship, prior planning, nothing else lordship. There is an incident happen lordship. People gather their lordship. Police take that advantage lordship, taking videographs lordship. Because otherwise, if they show their identity card lordship, this situation would not have
And my
arisen.
lord, this is not only one single case. In many cases, my lord, what happened when police went there, my lord, to my lord apprehend some of the accused. This is not that they are, my lord, group attack, my lord. They are in not. This is not only a single case. In many, my lord, in recent times, my lord, in many cases, my lord, this type of offense continuously, my lord, going on. And regarding the report regarding that AB, my lord, one Rafiqul Islam and Muhammad Saiful Islam, they are the, as per the report of the IO, they are the main culprit, my lord, of the initially, my lord, they started one item number 24, one Rafiqul Islam and Nurjahan Begum, my lord. And Nurjahan Begum is the wife of the main accused Baharul Islam.
Definitely, wife come
And
lordship protect the husband lordship because
and
when
item number
certain things
27,
happen
my
lordship.
lord, yes, regarding Nurjahan Begum, my lord, your lordship can consider, my lord. But regarding Rafiqul Islam, my lord, there are materials, my lord. He is the main culprit, Rafiqul Islam and one Saiful Islam of item number 27, my lord. So regarding that AB, my lord, except Nurjahan Begum, my lord, regarding other accused, there are because they are in interim in BA and considering their length of detention. Otherwise, my lord, there are materials against the accused.
The 24, 21, and report. It's submitted by Mr. Sheikh that the present not involved in the office. And their names are also not mentioned in the FIR, where 10 numbers of names of the persons have been mentioned in the if I have submitted, if I have submitted that on the day of incident, From the FI itself, it is seen that the police visited to the place of occurrence, arrest one Bahar Islam in connection with some cases, but all the police officers were in civil dress, and they were also they also took the vehicle. They also took a private vehicle, not civil, not a police vehicle. When they apprehended of the accused Bahar Islam, they raised human cry when lots of people, sneering people, came and gathered there, as there are many people were present who were watching the cricket match in the television. All the persons who gathered there had the impression that some persons may try to kidnap one Bahar Islam who made human cry. And with that intention, some of the people gathered there in the place of occurrence when the police arrested some of the accused persons. All the accused persons got arrested in connection with this case on 30/12/2025. And considering the nature of the case, they all were granted interim bail by its order dated 20/01/2026. And since then, they are cooperating in the investigation and not the and the cooperating the police station and cooperating and accordingly, Mr. Sheikh submitted that these accused petitioners may be released on bail, considering their earlier length of detention and the conduct of the accused petitioners. Mr. Waterford, the learned counsel, learned edition PP, submitted to Mr. that all these accused persons are involved in the alleged offense and alleged offense further from the matters available in the case diary. It is also seen that the police had to visit to the place of occurrence in civil dress and in a private vehicle, as in several earlier incidents, the villagers tried to clear away the accused person when they saw a police vehicle is come. Only to maintain the secrecy, police had to visit there in a civil dress when all the accused petitioners came and assaulted some of the police personnel who also sustained injury out of the said incident. One injury report is also available for one police officer. So the report says that the injury sustained by the police personnel is simple in nature. Mr. According to the raise objection and submitted that they may not be released on bail at this stage. Considering the submission made by counsel for both sides and also that it is the idea, saying that prior to the release of the accused persons in bail, they were in custody for sufficient for a reasonable period, and the IO got sufficient opportunity to interrogate them, keeping them in custody. Considering these aspects of the case vis-a-vis the materials available in the case diary, I find that further custodial investigation may not be necessary for the purpose of investigation. In which the interim bail granted to the petitioners all around 2001.
Lordship, not on all around 2101. Lordship, some are allowed in 91 also. If I'm not wrong.
I am on 21. 201.
191 Lordship. BA 99, it is granted on 91.
I will make a list and hand it over.
We'll see to it. Granted to the so and so in respect of PA number so and so respectively are hereby made absolute with same counsel. এটা হবে আপনার 21 কম পাইছেন 21 22 23 25 26 and 28
And 41 is there.
41 similar 41 141 more, one more 41 BA is there.
There is no interim.
There was no entry. BA to 41 to Beli. Heard Mr. B. Chaudhary, the learned counsel for the so heard Mr. B. Body, so and so. Same particular submission, same type of entry. Or what oral submission more or less. Since when he is in custody?
He is in custody from lordship 12 to 2026. 12 to 2020.
Not even a 1 month.
Yes, lordship, because lordship subsequent lordship here. Since on parity lordship here.
Also the ground of now up 24 and 27.
24 and 27, my lord, AB.
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 24 and
And against those accused persons, my lord, I have their materials. my lord.
yes. Heard Mr. B. Chaudhary, the learned counsel. Also heard Mr. P. Border, the learned PP appearing of state. These are so and so. It is submitted to Mr. Chaudhary that particular submission however, after obtaining the order of interim spill, these petitioners have appeared before the IM, cooperated with the investigation, and their statements are also recorded by the Mr. Chaudhary further submitted that petitioners are still ready and willing to extend their cooperation in further investigation in this case if they are provided with the privilege of reading. Next, Mr. Bott, the learned petition briefly submitted it that from the materials available in the case diary and the case diary, it is seen that these are the prime accused of the main culprit who helped the accused Bahar Islam get away from the scene when the police personnel visited the place of arrest. Though their statements were recorded by the IM, but they are not cooperating, not cooperating the way they should, but they are not extending their full cooperation, in the investigation of this case, and hence their custody interrogation may be required for the purpose of investigation. Next, for hearing this submission made by seen that after obtaining the order of interim spill, these petitioners appeared before the IO and their statements were also recorded. But from the note of the IO, it is seen that they are not extending their full cooperation in the investigation of this case, and it is also seen that they primarily help the accused Baharul Islam from being away from the scene. However, considering the present conduct of the accused who already appeared before the IO, I find that student interrogation may not be required for the purpose of investigation, but these petitioners are hereby directed to appear before the IO within 7 days from the date of order, and they cooperate in the investigation of this case. In any case, if there is any violation of the bail order, the order of interim order of the pre-arrest bail will be vacated with the above observation, the interim pre-arrest bail granted to the present petition is hereby dated to litigant is hereby made absolute with some same terms and conditions and with a further direction to appear before the IO within 7 days.
Highly obliged.
My lord, interim bail made absolute.
Yes.
Oblige, your lordship. Much so.
29.
29 is also. 29 is also, my lord, same.
29 is same.
Same Bipuria PS, man. 29
But
also.
he, Mr. Chaudhary went.
Yes. He, Ms. Chaudhary appeared.
It's same case out of same affair.
Same affair, Bipuria PS.
Oh,
244.
Just say anything about 29.
29, my lord.
Or Kusil department. Did he? Did he?
Yes, that is 22 to
22 to 29 he said, na? Oh, are we marked till 28 only?
Mala in the
Because
cause list,
29 is
yes,
not connected with this one.
connected. Yes.
I mean, maybe connected, but it is not with so and so.
Yes, yes.
Out of same heading, Mr. Chaudhary?
Yes, yes, same.
Okay.
Finding item number 30.
Nine. Oh, what about him? Have you informed him, Mr. Gogoi?
Yes, I already informed. But why they have not
informed? Na?
Already informed.
He'll be coming or what? At 2 also he can
Yes,
come. Otherwise, okay, then you
15.
May I please, Lord?
Yes.
My lord, this is pre-arrest bail application, my lord. What happened, my lord? Already one of the accused persons granted interim bail. Right order dated, my lord, 11 to 2026, page number 20, my lord. Allegation is that some bank officials of Mirza branch granted some loan to some borrowers violating the extent guidelines, my lord. What happened, my lord? The field manager collected the consumers and documents, my lord. The service manager, my lord, verified those documents and finally granted. And field officer has already been granted bail, my lord, interim bail, my lord. And the case is fixed
Your
for my lord.
petition-
My lord,
Your petitioner is working as a,
branch manager, my lord.
so you are the branch manager.
My lord, I was the branch manager. My lord, page number 13 is the FIR. The relevant portion is at, my lord, page number 18. May I read the FIR, my lord?
Yes.
It is to inform you that the concerned official of State Bank of India, Mirza branch, had sanctioned few express loans during the financial year 2023. The branch has undergone internal investigation, during which it has been observed that the concerned official who had posted at Mirza branch appraised personal loan for persons who did not get salary from their employer as per submitted employment ID, payslip. Rather, all these persons were getting credit from third party, and based on such and such, details of accounts are given below, my lord. Next page, my lord. It is further informed that the concerned official appraised personal loan to persons who were having history of return of settlement overdue amount in their CIC report. As on the date of sanction, all these loans were done by violating bank's extent guidelines. The concerned official appraised personal loan to persons without credit of salary in SB account of the borrowers. The net monthly income mentioned in appraisal were not credited in SB accounts of the borrower. Hence, the officials did not appraise the loan proposals with the required due diligence. Moreover, they appraised personal loans to persons who were not eligible for the proposed limit as per EMI NMI ratio. Existing obligations were not considered while calculating the eligible loan amount. The official appraised personal loan without the necessary pre-sanction survey, which were required because of conversion of category of SB accounts of the borrowers. Personal loans were sanctioned by MS Juri Daskoor. This MS Juri Daskoor, field officer, she has already granted interim bail. While permanent branch manager was present in branch, similarly persons loans were appraised by Mr. Mofidul Hussain being a service manager, while a field officer was already present in the branch for the same. There was no office order for this act in respect of sanction of personal loan. The officials appraised personal loan on the manipulated documents during appraising. The officials did not scrutinize and verify submitted documents, payslip, and statement of another bank account by the borrowers to ensure guidelines of the documents. It needs to be mentioned that the concerned officials deliberately did not follow the set-down procedure which are required for verification of documents prior to sanction of a loan. Their said act in the process implies that they, in collision with the borrowers, created a fraud on the bank and thereby causing loss to public money, as well as including a criminal act of cheating, criminal breach of trust, manipulation of official documents with a common criminal intent of causing criminal conspiracy. Now, as a matter of concern, the appraisal authority of the State Bank of India have given instruction to lodge FIR against the official involved. In accordance to this, it is requested to lodge FIR against hearing officials of offences committed by them, which include cheating, fraud, manipulation of official document, criminal breach of trust, which common criminal intent. The names of the concerned officer as given below. My lord, what happened, my lord? Already disciplinary proceeding started against them, my lord. I have been demoted and now I am working as a deputy manager at Gauhati branch, my lord. Already departmental proceeding started, my lord. Now, my lord, what happened, my lord? So far, the my lord field officer and service manager collected those documents, verified those documents, and after they forwarded this document to branch manager. As a branch manager, I have sanctioned this loan, my lord. My lord, none of the, my lord, this case has been lost almost after 2 years, my lord. The last incident happened in the year 2023, my lord. Now the FIR has been lost in the month of December 2025, my lord. They did not file any FIR, my lord. Soon after the occurrence, my lord, none of the borrowers made any complaint that these officials demanded some money from them, my lord, at the time of sanctioning loan, my lord. Moreover, my lord, at the time of sanctioning loan, the bank authority took some CODs, my lord. They can take any, they can start suit against them, my lord. They did not took any recovery proceeding, my lord. Although they have took some CODs, my lord, from the borrowers, my lord, nothing has been done, my lord. So, my lord, one of the accused person granting interim bill, I may be allowed to go on interim bill. I will cooperate with the investigation agency, my lord. If any adverse materials come, then my bill, my lord, should be rejected, my lord. As of now, my lord, I may be granted the interim protection.
You have also faced a departmental.
My lord, I have been demoted and now I am working as a deputy manager in Gauhati branch, my lord. Still, I am working at Gauhati branch. So, my lord, I will cooperate at any stringent condition, my lord. I will cooperate with the investigation. The next date is fixed on 10/5, my lord, 10/3, my lord. So, for a limited period, my lord.
Your lordship, my lord, while granting interim protection, your lordship may kindly come to page 22, my lord. I would just like to point out. And regarding my, he is the branch manager of the bank, my lord. And if my lord, he submitted that the recovery should be made from the borrowers, if loan sanction against some fictitious borrower, my lord, on the basis of some manipulated documents, how recovery can be made at this stage by the bank, my lord. So these are the persons, my lord, responsible on the basis of, he is the person responsible for verification of all the documents, my lord.
Service manager.
And your lordship may kindly come to page 22, my lord. Earlier, field officer was granted bail, my lord, as the field officer, your lordship may kindly come to 4th line, my lord. As the field officer, her only duty was only to see the borrowers in the field, and it was the duty of the other bank officials to verify the documents before providing loan to any person. So, my lord, he is the person, although field officer is also responsible, my lord, some departmental action has also taken against them, my lord, and bank has already lost, my lord, more than 15 crores, my lord. And this is, my lord, serious economic offense. And considering all that aspect, my lord, that he is a field officer and on the present petitioner is responsible for verifying all those documents.
No.
And
Service manager verified those
and
documents.
consider
I am not
at the
responsible of
time of
verifying the
submission also in the first page that the my lord petitioner's son is also appearing in class 10 board examination. Considering all these aspects, at that point of time, your lordship was pleased to grant interim protection to the present petitioner. And now, my lord, the present case is fixed on 10/3/26, my lord, case there. So, my lord,
10/3 can be fixed.
yes, on 10/3, my lord.
Well, till that interim protection.
No, so obviously there are some duties on the field officer and
My lord.
even the service manager also. But the branch manager is the person who is to verify all the documents
My
before
lord.
sanctioning any law.
My lord.
So suppose field manager is given any wrong report also. In
My
that case also it is duty of the branch manager
Yes,
My lord.
before sanction.
My lord.
And that is this tone among, you're saying that there is no complaint made
Fine.
by any, definitely borrower will not make complaint because
Fine.
all these are not the actual borrower.
My lord.
I mean, there are already some fictitious person against
Yes.
whom the loan was given.
My lord.
So they are not the salaried person.
Yes.
So from the salary account, nothing has been debited because they are not the
Yes.
salaried person.
My lord.
Now the bank is a loss of 1.5 crores.
My lord.
Yes.
My lord,
Maybe
already
your
departmental proceeding
requirement
taken,
may
my
not
lord.
be there, and as per you again, from your submission, it seems that you are already being demoted. That is,
Yes.
the department has already
My lord.
considered your thing. So
My
there
lord.
may be something.
And see, when
I am not separate, my
those
lord. I
my
have
lord
been
borrowers
demoted, my lord.
pretending themselves
I have not.
to be the my lord service holder of a particular department, but in fact, my lord salary slip was also not submitted by them at the time
No.
of procreation.
They are not-
So
not
that was also not
salaried
very
person, in fact.
only on the basis of some credit note, my lord, loan was sanctioned.
That is 10-3, my lord. So only limited period I will appear before the investigation agency, my lord.
CD was already called for
Already.
10-3, my lord. 10.
Mr. A. Paramanik, Ilan counsel for the petition, also had Mr. B. Bot, petition PP, an application. Submission made by Mr. Paramanik. And also considering the fact that one field officer has already been granted interim protection. In view of this, the present petitioner is also hereby granted some interim protection till the receipt of his diary with a direction to appear before the investigating officer and to cooperate with the investigation. Let the matter be accordingly listed on 10/3/2026. Proceed. Okay, your interim protection for till 10/3. So it may not be 7 days. Within 10/3, you have to report.
My lord, I will, at any condition, I will cooperate with the investigation agency, my lord. I will.
10/3. We are listing it on 10/3. Before
My lord.
10/3, you go there.
My-
Cooperate in the investigation.
Value.
Commission will work before 10/3. Before 10/3, we keep there. Before 10/3. Yes.
In this case,
30.
here, Lordship, we have the CD, but it need to be up to date, Lordship.
Needs updation.
Updation
Otherwise, he is in interim.
is interim, but his statements are not there.
Acha.
Whether
Not
he
there. And
appear or not, it
your
is also-
part is till when it is updated?
Lordship, it was last updated.
Last entry?
Last entry is 17, Lordship, 11.
17/11.
2025.
And can you tell us the interim order was?
Interim order was earlier, Lordship, 20 to 9. But the thing is that, Lordship, before this entry, 17/11, the earlier entry was before that was, Lordship, 19/8, 2025. But in between them,
Is the interim copy of order is there available? No.
I have not found, Lordship. I have not found in the CD, Lordship.
None appears on call for the petition. Mr. K.K. Ranjana, VP, agreeing on behalf of. If further submitted, that the CD received, but it needs to be updated as the last entry is on 17/11/2020. And that apart, the statement of the petitioner is not available in the case diary. So he was granted with the interim protection on 22/09. If you have later updated case diary, be called for return the in view of this return the case diary calling updated one. Raised the matter accordingly on 25/3. Interim be continued. 25/3. What is 32?
In this case, I am on interim, my lord.
You are on
But
interim.
on my lord, several occasions, my lord, CD is not coming.
What's the issue? Why you are not receiving?
Probably,
any
my lord, so far I have heard from my client, my lord, the charge sheet already been submitted, my lord.
Already
Submitted, but what, I have no charge sheet number, that's why I'm not, still now, yet to be confirmed, my lord. That's why date may kindly be given, my lord. Otherwise, it is how to know.
Submitted and also for the petition also. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25/3. 25 KK does United Edition bring on behalf of state CD not received. However, it is submitted by Mr. Ahmed that as per his information, the case has already been charged. But at present, he has no charge sheet number, etc. Next, in view of this, let a report be called for as to whether the case has already been charged. Or the and also the no, can I get you? In view of this, let the case diary be called for, and in the event the charge sheet is submitted, a report may be submitted by the I. List the matter when it can.
My lord, I will not be able to, my lord, on 17 if possible, my lord. 17th of March, my lord.
Okay, listing it 7.
My lord, interim may continue, my lord.
Yes, interim be continued.
Obliged, my lord. Much obliged.
So what is the position of 35? CD received.
We have recorded our statement, Lordship. Interim was provided. Lordship,
Yes.
the fact of the matter is regarding it, the alleged sections are under a theft. So if your Lordship may peruse the FIR, that is at page 13. Shall I read the FIR, Lordship?
Yes.
I have the honor to report that Mr. Shahidul Alam, the operations manager at Mandu, the escape resort, has been missing since the morning of 6 January 2026. He went to deposit an amount of rupees 4,60,948 on 6 Jan 2026 into Mandu, the escape's bank account at SBI branch Kohra, and has been absconding since then and is unreachable through any means since then. It has been confirmed that he has fled away with the aforementioned amount, 4,60,948, with the intention of committing a fraud. Now, Lordship, this was lodged by the informant, who is the owner of the Mandu resort, and we were granted interim on the last occasion. So we have recorded our statements.
Okay, what I have seen in the CD, Lordship, the thing is that he is working as a operation manager. Manager. He was supposed to, within a period of time, Lordship, he used to collect this money, what is the cash in hand, and he deposited it to that account, bank account. However, regarding this case, Lordship, it was he has deposited some money, which amount to 4,60,948 rupees. And fully in the CD, Lordship, there is a cash statement is there. According to it, Lordship, cash in hand is exactly the same amount. But I have also found that he has recorded his statement, and in his statement, he has stated that it is not the amount is not the 4 lakhs. He acknowledged that he has received that the money, but it has he has expended in some other things, Lordship.
Already expended.
He has Lordship spent the money. He has spent the money, but I have not found the documents. Whether any documents.
Spend the money in which? For his personal use?
No, he has to give some persons, Lordship, who gives this supplies, something like that, Lordship.
Related to the resort?
Related to the resort. But regarding that, I have not found any document.
So till now, he has not deposited any money to the bank?
No. He has not deposited the money to the bank,
Now, what he is saying then?
He is only saying that he has the money. It is not also that money, Lordship, 4,60,948. It is not the amount. It was something amount, 2,80,000. Another he has spent it.
No, the entire 2,80,000 he spent.
No, Lordship, he only received 2,80,000. He, according to him, Lordship.
And
the other money he has spent it on 18,000 to some elephant and jeep safari owners like this, Lord. But he has not submitted any document relating to that.
Whatever. Now 2,80,000. What is the status of 2,80,000?
It is also not received, Lord.
So he has given the return back the 2,80,000 where it is.
Lordship. Lordship, he has stated that rest of the cash money, that is approximately 2,80,000, has not been taken by it is on cash box. He has said it is on the cash box.
Still in the cash.
Oh, but the person who is with him, Lordship, he has stated that no, he has taken it the money, taken back the money with him.
And the money is not yet recovered.
Not yet recovered.
Lordship, if I may submit.
Mhm.
So the actual fact of the case was, as I have submitted on the last occasion, so he is an employee in that Mandu resort. So what has happened is, for the past 6 months, he was not being paid his entire salary. At first, deal was made between the owner and him that when he will be employed, his half salary will be given in an official manner, the other half will be given in an unofficial manner, which was their personal leave. So what has happened is, for the last 6 months, he was being paid the official amount, but the other amount was not being paid to him. So when he confronted the owner regarding the same, they denied the fact that they will not give him the remaining unofficial money. So on 6 Jan 2026, the accused person went to the resort to the owner and he handed over his resignation, stating that I will not work for you people. So what has happened is, after 14 days of that incident, the owner of the resort lodged a complaint stating that he has took the money. So our ground on the earlier occasion was
But your statement doesn't say so. You have give your resignation.
Your Lordship, what has happened in between is that on being granted interim, we have recorded our statement in Dolmara PS. So after which we have received a notice from Deothal police station stating that we have to appear before the OC, and accordingly we have appeared there. But now this is as per the instruction of my client that I got to know that when he visited the police station along with his advocate, he was pressurized to confess that he has taken the money, and if he won't confess, they are going to send the CD in a negative way. So accordingly, they handed a notice.
Your submission, how can
No, he was handed over a notice, which is there in our hands. If your Lordship may allow, we can place it on record. To appear before the OC of Deothal police station, 20 different police station on 28th of February, and accordingly,
Is there
he has
anything,
appeared.
this kind of things are there? Now she is submitting in one police station, she is appearing.
No, Lord.
Another police station asked to appear in another police station.
No, Lord.
How can we
The
say?
case was registered under Dolmara PS, but later, and we have recorded our statement there itself. But later on, we received a notice from Deothal police station, and that notice is with us.
But Deothal is how related with this? Your one is Deothal from Deothal.
Dolmara PS. Dolamara
No,
PS.
Dolamara, you
Is
have
where the-
appeared.
Yes.
Now you have received notice from which police station?
Deothar.
Deothar.
Deothar. Yes, Lordship.
These are which district? These two?
It's under Karbi Anglong.
Karbi Anglong. Is it there anything?
No, Lord.
Received already notice?
No, Lord. It is
This case is registered under
Dolmara. Dolmara 2.
Dolamara 2. Dolmara 2.
It is.
And why he is receiving 35T notice on Deothar?
In the CD, it is not there, Lord.
Huh?
In the CD, I have not found, Lord.
Deothar police station.
There are the documents regarding.
Not of same FIR or for the connection of other.
It is for the same FIR, but he has been sending notice from the other police station.
The notice from other police stations, same from for
Regarding
the same
in
FIR?
connection with this FIR.
Saying I don't
It is
And he
only
was
effort,
asked-
Lordship. I haven't found this.
He was asked to appear on 28th of February at 11 AM, which he did comply with. He did appear before that OC.
Yeah, the documents are relating to this case only, Dolmara, Lordship. According to his statement, Lordship, what I have said earlier also, 18,000, he has, according to him, 18,000, he has spent it, approximately 18,000 to different vendors of elephant and jeep safari. He has stated that he should be also give the documents, but I have not found any documents regarding that, Lordship. And he has stated that another 28,000, 2,80,000, it was in the box only, in the cash box. But it is his duty, if I look into the statement, it is his duty to earlier also on earlier occasion, he collected the cash and gave it to the bank lordship. It is his duty according to other witnesses, what I have found.
But must be state response. It is submitted to us that that the present petitioner appeared before Dolamara police station after obtaining the order of script, wherein he made some statement regarding expenditure on resort. Around 80,000 for the expenditure of the resort. He also stated that the remaining 280,000 is still in the case book. The other hand is submitted by Mr. M.S. Bora that the accused petitioner was bound to make make his confession regarding the receipt of money, though he has not received such amount of money, and rather he gave his resignation to the said resort. Further, he submitted in spite even after his appearance before Dolamara police station, he received another notice for the same FIR, in connection with same FIR from one due for police station under section 35(3), and in compliance to the said notice, he also appeared before due for police station who recorded his statement. In view of this, later detailed report we called for from the police station, Dolmara police station, as to why the petitioner was also asked to appear before the Uttar police station for the same FIR, and in the meantime, the updated case diary also be called for from the Consolidation station. In the meantime, petitioner is further directed to appear before the IO within 7 days from the date of order, and to record his further statement before the police station. In view of this, let the matter be listed on 24/3/2026. Interim be continued. Return the calling for the report.
Yes, sir.
Why 24/3?
May I plead the lordship? I'm sorry, my lord, I have a preamble regarding item number 37, madam. In this case, my lord, a report was called for, probably report is not received, my lord. And my lord, so next date may be given, my lord.
You are on interim.
Yes, my lord, interim coercion has not been
No,
taken.
whatever that interim was there.
Yes, my lord.
Was it there?
Yes, my lord.
In 37, you have not received the report? Report not received. Interim be extended. The 19th will do or 17th?
My lord, it may be after Eid, my lord. 22, 23.
23.
Yes, ma'am.
23.
Yes, ma'am. I'm obliged, ma'am. Obliged, ma'am.
Most probably you most probably he also said
Yes,
number 29.
Yes.
And we missed it. And then I thought that up to 28 only because it is not connected. Connected means it not which is not
Which was not mentioned.
which was not there. So I thought that anyway we passed the order.
There was no interim lordship, only date of arrest is 6/2 lordship. That much. Lordship.
Oh,
Regular
interim
bail?
was not there, na?
No. Lordship. Regular bail.
Okay, we'll make the instructions.
Highly obliged.
May I please, Lordship, item number 20, 13.
Yes, 13 here.
Yes,
Yes, Mr. Sharma.
My lord. Sorry, my lord.
No, it's okay. Yes, citizen AB, na?
A notice was served to the accused person to appear before Crime Investigation Ranch, Biswanath Wildlife Division, Kaziranga National Park, Gomidi Ranch, And the accused person is ready to appear before the IO lordship. But he needs
What
to
is the case?
some protection.
What is the case in fact?
Case in page 10 lordship.
Page
As
10.
per intelligence impute about an attempt to rhino poaching at Kaziranga National Park and Tiger Reserve area by a group of people. A search operation was carried out at Raunamok Bejisuti area and able to detain one person, namely Biswarup Mili, from his residence. Later, he was brought to the custody of Eastern Range Gamiri Forest Office. As per interrogation, he has confessed he and other accomplices were planning for rhino poaching at Kaziranga National Park and Tiger Reserve. Later, 2 nongs of handmade 12 bore leaf animation, 1 mobile phone with 1 SIM card, and 1 Assamese gamusa were recovered and seized. 4 accused was arrested in this case, lordship, and notice was served on me on 21/2/2026, page 16, lordship.
Mr. Sharma, whether this prior to this investigation or whether any rhino killing was there or they
My lord, rhino poaching is not there,
was
but
there?
my lord, attempt, my lord,
No,
attempt.
attempt was there.
The attempt was there, my lord, and my lord, at this stage, my lord, offense report may be called for because, my lord, the complicity only, my lord, it is known, my lord, my lord, in the offense report, my lord. So, my lord, how much, my lord, they have been involved, my lord, how they involve or my lordship knows that it is a my lord, organized crime, my lord.
Then obviously.
So, my lord, their complicity, my lord.
Even the
But,
accused
why 35(3) is issued to him?
My lord.
But 35(3) was issued to me.
My lord.
That was issued to
Even
me.
the accused person has no knowledge as to why they served notice to them. Another 2 bail application is pending before in court number 23. Say from the same arising affair. Another 2 accused.
Today itself.
Yes, today itself.
No, now otherwise, what is your how you are connected?
I am
Why
not
you are
connected.
supposed to be
I am not connected.
What
I
you do?
even I don't know as to why they call me to in regards of investigation purpose. But I'm ready.
What do you do otherwise?
I'm ready, Lordship.
No, otherwise, what is your profession? What do you do? What is
No, I am actually businessman.
Pardon?
Businessman.
You are a businessman?
Yes. Having tractor, working in a field.
Here, the name of other accomplices are not there.
Yes,
Mr. Sharma.
my lord.
He said that other accomplices.
Mm.
Who maybe the other accomplices is not there.
There's a reasonable ground to question you to
That's
assert
why
actions.
I'm moving this honorable High
You are
Court.
directed to.
I'm ready, Lordship. I'm ready for a corporate investigation. But I need some protection.
Otherwise, my lord, some person arrested.
Yes, there are 4 persons arrested.
In this case, my lord.
Some persons have already been arrested.
Yes, my lord. Kindly have a look at my lord. The page number.
14.
14, my lord. The forwarding, my lord.
This is Bimal Pasang, Ronoj Papegu, and Jabaguru Pegu, Biru Pegu.
Initially, another person was caught, na?
Yes. FIR on 29/11/2025.
heard Mr. G. Fuqua, the learned counsel for the petition. Also heard Mr. B. Sharma, the learned special PP Assam, unauthorized special PP Assam. This is an application, section so and so, connection so and so. It is submitted by Mr. Fuqua that the present petitioner is no way connected in the alleged offense. However, he received 35 free notice from the department concerned to appear before the investigating officer. He is ready and willing to extend his cooperation in the investigation of this case. As he has already received the notice, there is apprehension of arrest, and hence some interim protection may be provided to the petition so that he can appear and cooperate with the investigation. Next letter, Mr. Sharma, the learned special PP submitted in this regard that an attempt was made for Rhino poaching, and in view of this, one person was initially arrested, and thereafter 4 numbers of people have already been arrested in connection with this case. Accordingly, he submitted that offense report may be called for. This report may be called for to know the involvement of the considering the submission made by the council state. And the case study along with the offense report be called for. And further considering the submission made by the finance counsel for the petitioner, interim protection may be provided in according to it till receipt. Okay, you are giving some interim protection, appear before the IO, cooperate in the investigation.
Yes.
Listing the matter on 24th he will do,
My lord. 24th,
24th of March.
my lord.
Publish.
Order. Yeah, it's the Anna. Oh, the internal lighting. Oh.
My lord, here we have received the case there, my lord, without the injury report, my lord. Here the section 109 is there, my lord. Here and the injury report is required, my lord. Here petition number 2 and 3 are in interim.
2 and 3.
2 and 3, my lord. And 1 and 4 not considered by the lordship, my lord, in the earlier.
My lord, the figure 4 is the application, and here is section 1091. There I also think the injury report is necessary to determine this bail application. At the same time, my lord, I have a limited prayer. Already 2 and 3 are in interim period, Your Honor. I think 1 and 4 should be protected by granting interim protection. Your Holy Ramzan is going on, my lord. Yes, because Your Honor, my lord, 4 is the outsider. There, he is not family member. He is a minor son also, and he
to do.
yes, and he also minor son, and he is an employee of DC office, and he is not able to appear his duty also.
What to do?
So, my lord,
Do you want to retain the case there?
My lord.
It can be retained.
My
so
lord,
that
we will
can,
retain the case there, my lord.
It's a short date.
My lord.
in the meantime, interim protection.
No, my lord. Here in the interim order, lordship, kindly please interim order, my lord. Para 3, my lord.
Yes,
All
only considering that
is, my lord,
consideration.
66 years and 60 plus, that's only considered, my lord. And para 4, my lord, 1 and 4 is not considered at this stage.
4 is not related with the victim, Your Honor. 4 is outsider. 4 is outsider. He is brother-in-law victim. And so far, my instruction is concerned, my lord, the victim is now doing job also. She is only 1 day she approached medical. After this, she is doing her
Now
job.
she is good condition.
So, my lord, considering all this, my lord, interim protection will go 1 to 4 till disposal to receive the injury report, Your Honor. After receiving the injury report, if something is there, then Portal was
My lord,
necessary.
here, prayer for medical examination report of the dear my lord, from IO, my lord, and from where it reveals that my lord, she was in 3 days hospitalized. And after 3 days, she was discharged from the hospital. That is here.
Okay, let us see the injury report.
Ma'am.
Heard Mr. N.K. Haloi, the learned counsel for the petition. Also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state. It is submitted by Mr. Sharma that CD received, but the injury report is not available, which will be required as the case is registered under section 109 PRS. In view of this, let the CD be written, and the additional PP will take necessary will do the needful in procuring the injury report from the concerned IO. The one can be listened. Give a short date.
My lord. Today is my lord. 16th, my lord. 1/6.
1/6 will do.
Uh,
Today's 5th.
before, আগত পৰে থাকিব।
নাহিলে আৰু ই হৈ যাব। Then 13th, my lord. 1/3.
The matter will gested on 13th
My
week, and so interim granted to the petitioner, accused petition number 2 and 3 be extended till next year. Okay.
Okay.
So what is the position of
My lord, CD received, my lord. Well, earlier rejected, my lord, after going to the record, my lord, and perhaps there is no new grounds at present, my lord. That's why kindly place the rejection order, my lord. Page 21, my lord, of their petition, my lord.
Yes.
And page 2211, my lord, para 5, my lord. Claim for a minor dead person who is earlier already died, my lord. And thereafter they have some minor documents were minor fake documents were produced before the insurance company and claim for 9 lakhs rupees, my lord. Here, my lord, in the opening form, my lord, policy opening form and bank opening for her daughter's name or photos were used, my lord. That is, Lord Chima, kindly please, it will be clear from page 22, my lord. Married, my lord. Mr. Sharma learned additionally so and so. The accused person, including some others, are involved in alleged offense. The present accused petitioner has prepared a fake policy in the name of wife of the petitioner number 4, who died in 2018. And by creating some fake identity and some documents, the policy is created and showing the accused petitioner so number 4 as the nominee of the policy. They all claim rupees 9 lakh as a policy holder. He further submitted that they not only created some fake documents to open the policy, but also used the photographs of the daughter of the accused petitioner number 4, showing herself as Prathoni Rabha, and against the policy is obtained with the fake identity. He accordingly submitted that all the accused people are fully involved in the offense, my lord. And objection. Thereafter, my lord, lordship observation, my lord. Para 6, my lord. I have perused the case diary and statement made by some of the co-accused and the witnesses. It is seen that all the accused persons are fully involved in the organized crime, wherein they have created a fake insurance policy by using the ID of Nur Alam Sheikh, the petitioner number 3, in the present case, and thereafter by obtaining the insurance policy and by obtaining fake death certificate, and also after obtaining some signatures of some of the witnesses, a fraudulent claim of rupees 9 lakh was made as the insurance claim, showing the petitioner number 4 as the nominee of the policyholder. So there is no such policy exists in the name of the wife of the so-and-so. They also use the photograph of the daughter of the accused petitioner number 4 to make the fraudulent claim of the insurance policy. Considering the nature of offense, the way of the offense was committed, that it was rejected. Perhaps thereafter investigation going on, my lord, some of the, it was the organized crime, some of the accused are yet to be arrested, my lord. And perhaps no new grounds here they have given any.
Lordship, in the submission made by the learned additional public prosecutor, Lordship will see that to the present petitioner, that is Samsing Rava, no special overact has been attributed to him. No special role has been attributed, Lordship. The only thing written here is that they are fully involved. No specific role has been attributed, Lordship. And
Who are you? Your petitioner is Tenchi?
Lordship, Samsing Rabha, petitioner number 2, Lordship. Here, the petitioner number 4 is mentioned, the petitioner number 2 is mentioned, accused, the wife of the accused, petitioner number 2. The Lordship, this is wrongly written, Lordship. The wife of the petitioner in the para number 4, Lordship. Para number 4 of the order. Page number 22. Page number 22. Para number 4, where it is written that, where it is stated that the said Pratnani Rabha, the wife of the accused, petitioner number 2. She is not the wife of the petitioner number 2, Lordship. She is the wife of the petitioner number 4, Lordship.
Subsequently, it is clarified.
Yes, Lordship.
Subsequently, it is clarified that she is the wife of petitioner number 4.
In the earlier case, my lord, here
Now, how many petitioners are here?
only one.
Only one.
Only one,
Samsing
Lordship.
Rabha.
Yes, Lordship. His name was not in the FIR. No serious accusations has been made against him. And also, Lordship, in this matter pertains to document verification. And already the evidences, the documents are already in the custody of the investigating officer, Lordship. And hence, this does not warrant any custodial interrogation of the applicant, Lordship. And Lordship, while entertaining a bail application, Lordship, 3-4 things have to be considered, as your Lordship is aware. Firstly, the seriousness of the offense. Admittedly, the offense is serious in nature, Lordship, and also the seriousness of the accusation has to be taken into consideration. In the case of the present petitioner, no serious accusation has been made. And the second criterion.
From where you are saying no serious accusation has been made?
Lordship, his name is not in the FIR, not in the complaint. No accusation has been made. The second criteria is there any chance of him fleeing? Lordship, he is willing to cooperate. He has a 4-month daughter, 4-month male child, Lordship, and a wife. There is no chance of him absconding. Thirdly, Lordship, he does not have any prior criminal record. Fourthly, Lordship, is there a need for custodial interrogation here? Lordship will see that.
He, in the earlier petition, he was the petitioner number?
Petitioner number 2, Lordship. And Lordship, it has also it is to be taken into consideration whether there is any risk of misuse of the protection granted by the Honorable Court. Already the evidence is in the custody of the investigating officer. There is no chance of him trying to tamper with the evidence. And he is not an influential person, Lordship. He is just a driver by profession, Lordship.
My lord.
And also, your Lordship, in a previous matter which involved financial fraud, Lordship, your Lordship has granted PRS bail, Lordship. With under the same section, Lordship, the same FIR was lodged under the same section wherein Lordship has granted PRS bail, Lordship.
That is a different case, my lord.
Different
In different facts are different, my lord. Facts and circumstances. My lord, here, first of all, my lord, I have already submitted, my lord. In the policy opening form, my lord, daughter's name was used, my lord.
The daughter is of the daughter.
This is my lord. This is my lord.
Rajiv Rabai.
Who died in the year 2018, my lord. And the documents were prepared in the 2021, my lord. 2021. After bank opening form, my lord, daughter's photographs were used, my lord. Fake death certificate prepared, my lord.
The present petitioner is not the father of the daughter.
No, I am saying
the father of the imposter.
After fake cremation certificate, my lord. And use, my lord, in the cremation certificate, Gaubra signature was also taken, my lord. In his statements are also there, my lord. He said that, my lord, here, Lordship kindly peruse the IO note, my lord. Here, all of the documents without any verification, my lord. Whether that person alive or not, when died, that from the doctor to the, my lord, from A&M nurse, my lord. Does A&M nurse prepared this? Thereafter, it was sent to the pharmacist. Pharmacist placed before the doctor, my lord. Doctor also signature. All of them, my lord, here. Is really done, my lord. Here, Lordship, may kindly peruse 1-2 statement, my lord. How he is involved, my lord. He is one of the prime accused, my lord. petitioner is a Samsing Rava, Samsing Rava,
Yes.
my lord.
Oh, he is the prime accused.
All the documents are fake. And all the witnesses said they say was that disease was died in the year 2018, my lord. But they prepared in the 2021 saying that husband, my lord, he will get some benefit from the government, my lord, and he is not aware about what they are going to do.
One is Gaupra is also there. No?
Another Gapura, my lord, another part to some. Even death certificate they have prepared, my lord, and cause of death also given to the doctor. My lord.
So bank officials are also in.
My lord, all of
Lordship, here the prime accused is Noor Alam and Rajiv Rabha. Noor Alam is the one who sourced the policy. Rajiv Rabha is the one who used the photo of his daughter, who made death claim. Nowhere in this entire scenario, the name of the
You are the prime accused. You are the main who just first approach the person who's against whom
Rajiv
there is
Rabha, my lord.
Rajiv Rabha.
This is a
You are the
husband of
main
the
person who approached him and who approached the Gaupra to obtain all the certificates. You are the main person. Okay. RMS, you are MS?
M Das Lordship. How will Lordship?
RMS M. No, wait, RMS M. That's still an also for it. And also heard Mr. B. Sharma, the learned edition PP, agreeing on behalf of state respondent. It's an application of section so and so in connection with so and so stated with next by it is submitted by MS M. Dust because the counsel for the petition that he is innocent and he is no way connected in the LS office. It is a fact that his earlier bail application was rejected by this court. But while rejecting the bail application, also there is no mention about the any special any acquisition made against the present petition. He neither he made any policy nor his policy in the name policy the fake policy, fake insurance policy, nor he is involved in the said office. It is one Rajiv Brahma and the two other persons who basically involved in this case, wherein it is alleged that they have made a fake policy in the name of the wife of the one Rajiv Brahma, who and the police who died in made name of one police Rajiv Brahma, wherein it is also alleged that in the place of his wife, the daughter photo identity of his daughter was produced before the concerned authority at the time of opening the policy. But the present petitioner, Samsung Rava, he is no way connected in the offense and Elizabeth Post. Further, she submitted that all the documents are in custody of the investigating officer, and hence there is no question of any tampering with any documents or the other evidences, the witnesses. Post. Further, she submitted that there is no though the nature of allegation is serious, but present there is no accusation against the present petition, and that apart there is no chances of fleeing away, no chances of absconding of the present petitioner if he is provided with the privilege of pre-arrest bail. Rather, he will extend his cooperation in the further investigation of this case, and will cooperate in the rather he extend the cooperation in the further investigation of this case. She submitted that while moving the earlier bail application, this particular facts was not brought into the notice of the court, and his earlier bail application was also rejected along with the other petitions. Next paragraph, Mr. Sharma, the learned additional PP submitted in this regard that the present accused petitioner is the prime accused who basically initially approached the husband of the accused Rajiv Brava, and then he also approached the Gauhati for creating a fake insurance policy and obtaining, and to that effect, he also obtained the signatures from the Gauhati and other officials. Mr. Sharma further submitted that the policy was found that there is no any new ground for consideration of bail for the present accused petitioner, whose earlier bail application was rejected by this court. Mr. Sharma further submitted that the wife of Rajiv Brava, the one of the accused, died in the year 2018, and the policy was was opened in the year 2021, wherein fake death certificate, even fake cremation certificate, and Gauhati's certificate, etc., were produced for the authority for procuring the for at the time of opening the policy in the name of the wife of Rajiv Brava. That apart, the photographs of the daughter of the accused Rajiv Brava was produced at the time of opening the policy, and he further submitted that in the present case, they say that is an organized crime wherein even from NNM nurses, the doctors, and the other bank officials also involved in the said office, wherein in the name of a fake insurance policy, they tried to enumerate rupees 9 lakhs in the name of the policy, maturity of the policy, the matured sum of the policy. Mr. Sharma accordingly raised payment objection and submitted that it is not at all the case to extend the privilege of pre-arrest bail to the present petition. Next, hearing the submission made by learned counsel for both sides, I have also perused the case diary and the case report. It is seen that in the earlier, while rejecting the earlier bail application, the following observations were made by this court in paragraph 6 of the said order, which read as follows. Here I place 22 paragraph 6. Next paragraph, after perusal of the case diary, it is seen that the present petitioner is the prime accused who first approached the other accused Rajiv Brava for opening a fake insurance policy, and thereafter by he also contacted the Gauhati and other officials for obtaining the signatures, wherein the other accused persons also cooperated him, and Thus, with their cooperation and in an organized manner, the present petitioner, along with the others, were involved in creating fake insurance policy by using the ID of one Noor Alam Sheikh and by producing the photographs of the daughter of Rajiv Rava, showing her to be the deceased Prathani Rava. Thus, all the accused petitioners, including the present petitioners, had committed the crime, which is very serious in nature, and accordingly, and it is also full stop. It is also seen that the many other persons are yet to be arrested in connection with this case, including some other assets wherein the some bank officials and other rank officials, doctors, and other persons may also involved in the LS files. In view of this court is of opinion that the present petitioner, does not deserve a privilege of pre-arrest bail. With the above observation, the present bail petition stands rejected. Your petition stands rejected. Part 2.
May I please, Your Honor?
Some part heard was there, no?
Part heard, I'll just give the facts, just gist of the facts, because
Okay,
it was done in the month of January.
Your Honor, in this case, the party in person, he will argue this case, Your Honor. He is a respondent number 5. Also, in professional as an advocate also.
Respondent number, you are the respondent number 5.
5.
So he will appear for his own case and other rest.
Other is, Your Honor,
1, 2.
1 to 5.
Huh? No, he is 5.
He is 5, but 1 to 5, I am the youngest advocate, but they are brother and sister. All are brothers and sister. And 9 and 10.
No, he is appearing as an advocate or as a person and only for 5.
Oh, no, on behalf of them also.
Huh?
On behalf of
Can
them
it be possible? Have you filed Bukaratnama for others also? In a person, as a personal strength, you can appear in your own case, it's okay. But for others, you appear.
Others, he is there.
Okay. My name
For others, he is there, my lord.
You can appear for others.
He can adopt the argument.
Yes. Can appear.
May I proceed?
Yes.
Hello. May I please respond? Well, here in the instant case, my lord, when plaintiff, my lord, filed a suit, title suit 105 of 2017, that my lord will find at page number 16, for declaration of right title interest, recovery of possession, and other consequential reliefs, my lord.
Page number?
Page number 16 is the plaint. And the prayer portion, my lord will find at page number 31, and it continues. Suit was
filed by whom?
Suit was filed by the plaintiff.
Respondent now here, respondent.
So, my lord, it was filed for declaration, recovery of possession, and other consequential relief.
Okay.
So, my lord, in that suit, if my lord comes to page number 32, my lord, the patta number and the DAG number, my lord may make a note. My lord had already noted last occasion, but again, my lord, patta number is 180, old DAG number is 508, and new DAG number is 498. It is covered by Khatian number 351, 354, and 106, my lord. This is very important, my lord, the DAG numbers.
DAG number, sir, one is,
My lord, in the plaint, the DAG number that is the disputed land is DAG number 498. Patta number is 180.
which is covered by Khatyan number 351, 354, and 106 at page 32.
Yes.
Thereafter, my lord, against the issuance of notice, my lord, the defendants appeared, that is the part of the respondents, and they filed a written statement, come counterclaim. The counterclaim, my lord, schedule will find at page number 54.
No, who are you then? You are also not.
I am not a party, my lord.
Oh, acha.
I was not made a party.
Oh.
That is my first point. So, my lord,
So those defendants are also here as a respondent.
respondents, they are also there.
So they filed their WS and counterclaim.
Counterclaim, and schedule of the counterclaim, my lord, will find it page number 54. There also, my lord, dark number is same, 498, patta number 180, but the Khatyan number is 354, my lord. And Moza is also Suprakanti. So with regard to the dark number, patta number, and Khatyan number, my lord, there is no dispute.
Yes.
Thereafter, my lord, one find that the defendants, they filed a petition that my lord would find at page number 71. Annex 6.
Yes.
Relevant paragraphs, my lord, paragraph number 4 and 5. I'll read paragraph 4, my lord. That the defendants, after getting information for the illegal acts and deeds of the plaintiffs, the defendants forthwith submit. Paragraph 3, my lord, that during the pendency of the instant suit, the plaintiffs in collusion with others tried to withdraw the amount of compensation of land acquisition which is acquired by the government of Assam for the Bharatmala project. That the defendants, after getting the information for the illegal acts and deeds of the plaintiffs, the defendants forthwith submit complaint petition dated 19 to 24, 28/11/24 before the District Commissioner Sribhumi, and also a copy submitted to the Circle Officer, Sodor Circle, Sribhumi, Assam, not to disburse any compensation amount in favor of the plaintiffs and others attracting the land of the partition deed number 2978 dated 19/5/2004. But the District Commissioner or any other officials did not pay any heed to the defendants. Rather, they tried to disburse the said compensation amount. Verify that considering the facts and circumstances, the defendants finding no other alternative and submit this petition for passing necessary order, direct the District Commissioner and his officials, that is LA Branch Sribhumi, not to disburse any compensation amount in favor of the plaintiff or any other persons by attracting the land of deed number so-and-so, which is under challenge by the defendants before the learned court in the instant case, which attracts DAG number 293, Patta number 288, Khatyan number 135. My lord may take a note that DAG number, what they are insisting is that DAG number 293, Patta number 288, Khatyan number 135, Moza Lokkar Khai. Whereas the suit land, my lord, falls under Moza Suprakanti. And DAG number, Patta number are also different. Be directed to submit compliance report to the learned court, otherwise the defendants will be prejudiced. In view of the above facts and circumstances, it is appropriate that your honor would be graciously pleased to pass necessary order, direct the DC and his officials, that is LA Branch Sribhumi, not to disburse any compensation amount in favor of the plaintiff or any other persons by attracting the land of deed number so-and-so in respect of DAG number 293, Patta number 288, Khatyan number so-and-so, which is under challenge by the defendants before the learned court, and further be pleased to pass any other orders that the court may deem fit and proper. This petition was filed on 28th of February 2025. And the learned court below, my lord, on the very same day, that my lord will find at page number 75, Annex 7. That is dated, order dated 28 to 2025. On the very same date, my lord, had passed this order, impugn order. Last paragraph, my lord. In view of the extreme urgency, this order is passed without hearing the plaintiff. Without hearing the plaintiff, as non-granting of immediate relief may render the suit infructuous and lead to injustice. However, such an order does not cause any prejudice to the plaintiff since the matter remains sub judice before this court. Accordingly, the District Commissioner, Sribhumi, is directed not to disperse the compensation amount to any person, my lord, not only to the plaintiffs, any person who is not even a party to the suit, until further orders of this court. send a copy of the order to the District Commissioner Sri Bhumi. So my lord, this order was passed. I was not made a party, neither the plaintiffs were given an opportunity to file any objection, my lord. When I came to know about passing of this order, my lord, then I immediately find an application that my lord will find in the very next page, Annexure 8, page number 77. Abdul Hamid had filed this, the present petition, third party petitioner above name. Most respectfully swear that the third party petitioner and others are the bona fide owners and possessors of land covered by new DAG number 293 under Patta number 288 of Moja Lokharkhaya under Pargona Kusarikul, which is not the suit land of the instant suit. That the suit land of the instant suit is pertaining to DAG number 498 under Patta number 180, Khotia number 351 of Moja Suprakondi. The counterclaim of the defendants is also in respect of DAG number 498, Patta number 180, Khotian number 354 of Moja Suprakondi. That's so the land of the third party petitioner covered by new DAG number 293 and Patta number 288 of Moja Lokharkhaya is in no way involved in the instant suit or counterclaim. The third party petitioner and others have been selected for compensation against acquisition of land under Bharat Mala project. The defendants, counterclaimants have personal grudge against the third party petitioner. So to stop the compensation of the third party petitioner, the defendants have filed petition number so-and-so dated before this learned court, falsely stating that the land of DAG number 293 of Patta number 288, final Khotian 135 is the suit land of the suit, and by misleading and misguiding the learned court, has obtained the restraint order dated 28 to 2025 without hearing any side. Subsequently, the defendants have submitted the order dated to the District Commissioner Sri Bhumi and approached not to disburse the compensation amount to the plaintiff or any person against the land of DAG number 293, Patta number 288. So the District Commissioner Sri Bhumi has stopped the disbursement of compensation money to the third party petitioner, for which the third party petitioner has been suffering very badly. The order dated 28 to 25 is misguiding and misleading order obtained by the defendant fraudulently, and as such, the third party petitioner has prayed for setting aside the order dated so-and-so. In view of the above, it is humbly prayed that so-and-so perusal of plaint and counterclaim be pleased to set aside and vacate the order dated 28 to 2025 on the ground that the land of DAG number 293, Patta number 288 is not involved in the suit. Otherwise, the third party petitioner shall suffer suffer loss and injuries. A similar petition was thereafter, my lord, filed on the same day by the plaintiff also. That, my lord, will find it annexure number 9. Same petition, my lord, I will not be reading. Thereafter, my lord, at page 84, my lord, will find the written objection that the present respondents had filed, that is the defendant number 1 to 5 and 9 to 10. Thereafter, my lord, after hearing the parties, the learned court below had passed the impugn order that, my lord, will find it 29/4/2025 at page 91. Annexure 12.
Ninety-one.
Annexure 12.
Hey. Order. 90. Please, number 90. Yes, 91.
My lord. Order dated 29/4/25. Parties are represented. This petition is filed by the plaintiff petitioner seeking to set aside the order dated 28 to 25 by which this court had directed the deceased Sri Bhumi not to disburse the compensation amount to any person in respect of the suit land until further orders. The ground urged by the plaintiff petitioner is that neither the schedule of the plaint nor the counterclaim mentions DAG number 293, and therefore the stoppage of compensation in respect of DAG number 293 is unjustified. The opposite party defendant filed objection and submitted that although DAG number 293 is not specifically mentioned in the schedule of the plaintiff of the counterclaim, he has in his counterclaim sought a declaration concerning deed number 2978 dated 19/5/2004. It is pointed out that the said deed pertains to land situated at Musa Lokorka under Kotia number 135. The defendant has also submitted a photocopy of the Jamabandi, which shows that deed number 2978 dated 19/5/2004 corresponds to DAG number 293. Heard both sides. Upon consideration of the pleadings and materials placed on record, it is evident that the validity of deed number 2978 dated 19/5/2004 has been challenged in the instant suit. The said deed includes land covered under DAG number 293. Although the DAG number is not explicitly mentioned in the schedule of the pleadings, the connection between the impugned deed and the DAG number in question is established through the Jamabandi records submitted by the defendant. It is a settled principle that when a deed is challenged in a suit and that deed pertains to a particular land, any order concerning the subject matter of the deed must include all properties described in. Therefore, until the issue of validity of the deed is adjudicated, any compensation relating to land covered under the said deed must be withheld to avoid prejudice to the outcome of the suit. Accordingly, the court finds no merit in the petition filed by the plaintiff petitioner. The petition is set aside. Petition to set aside the order dated so and so is hereby rejected. The said order shall continue to remain in force until further orders of this court. So, my lord, my petition as well as the petition filed by the plaintiff, that was dismissed on the ground that, my lord, the DAG number.
But regarding your petition, it is
plaintiff
not-
petitioner, my lord, public petition.
Plaintiff petitioner, not you.
My petition was also considered, my lord.
So I don't think so.
My lord, page 93 is there, my lord. Parties are please petition filed by the third party petitioner seeking to set aside the order dated 20 to 25 by which this court had directed the district commissioner not to disburse the company was
The
any
third party petitioner, where is there?
Lord, second line. Parties are represented. This petition is filed by the third party petitioner. Page number 93. Last page.
What's it? It is continuing.
Well, this is again on passed on the same day, my lord.
What is the 93? and
Since
the order?
that petition was dismissed, my lord, so accordingly this petition was also. So, my lord, here the petition is filed by the third party petitioner seeking to set aside the order dated 28 to 2025 by which this court had directed the district commissioner Sri Bhumi not to disburse the compensation amount to any person in respect of the suit land and until further orders. In the light of the final order passed in Miss Case number 336 of 2025, the instant Miss Case is also dismissed. My lord,
The light.
in the light. So, my lord, here, my lord will find that the learned court below has dismissed my petition only on the ground that, my lord, the DAG number and the Patta number and the Khatian number, it is reflected in the partition deed, my lord, because they have challenged the partition deed. As such, my lord, since the suit is pending, subject is before the court, it should not be, compensation should not be disbursed. But here I am taking 4 points, my lord. I'll come point wise. I'll be very brief in my submissions, my lord. First point is that whether the learned court below had jurisdiction to pass this order. Learned Munsif Court, that is direct the DC Sri Bhumi not to disburse the compensation amount. My lord, may kindly take up Right to Fair Compensation and Transparency Acquisition Rehabilitation Act 2013.
Right to fair.
My lord, may take up section 63 first. Page number 37. It will be same page.
Yes.
63. Jurisdiction of civil courts barred. Right. No civil court other than High Court under Article 226 and under Article 227 of the Constitution or the Supreme Court shall have jurisdiction to entertain any dispute relating to land acquisition in respect of which the collector or the authorities empowered by or under this act and no injunction shall be granted by any court in respect of any matter. So this section specifically states that, my lord, civil suit is barred first. Secondly, no restraining order or any injunction order can be passed directing any party or the acquisition authority not to disburse the amount. It is specifically stated, my lord, section 60, that civil suit is barred. So, and this order also, my lord, that is 28 to 2025 and 29 for 2025, that was passed in a civil suit. And directing the authority is also not a party, and the parties who are affected, they are also not a party. That is the present petitioner, my lord. First is, my lord. Secondly, non-implement of both the parties, my lord. DC is not also a party, we are also not party. Section 60, and if, my lord, there is any commotion or any disturbance with regard to the amount that is to be apportioned, my lord, that is also taken care of by section 76 of this same very act, my lord. This act is a, my lord, self-sufficient code, my lord. It guides everything, my lord. Section 76, my lord, may take up dispute as to apportionment. If there is any dispute with regard to the compensation amount, my lord, what is the remedy then, my lord? First remedy is to approach the High Court under Article 226 or 227. Then regarding, my lord, if there is any dispute to apportionment, section 76 is taken care of. When the amount of compensation has been settled, as in our case, if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the authority. And who is the authority, my lord? That is again taken care of in section 53. Authority is a district judgment. That is a reference code. My lord also knows, my lord. That is the reference code that will take care of any dispute with regard to acquisition, my lord. My lord, now second point is, my lord, which the learned court has held that, my lord, the partition deed involves tag number 293 and patta number 288. My lord, I have already on the last occasion given the partition deed. My lord will find it. Yellow color flag mark, my lord, last. At the last, my lord, very last. Oh. Yeah. Yes. My lord has got it. Yellow flag mark. This one. So, my lord, I have highlighted the dark numbers, patta numbers of the top schedule, my lord. There are a number of schedules, my lord. My lord will go through it. I'll not take time, my lord. No, none of the schedules as mentioned in the partition deed, my lord, refers to Khotian number 135, patta number 288, dark number 293, my lord. I have highlighted all the dark number and patta numbers. I have gone through it a number of times, my lord. Even my colleagues assisting the matter, they have also gone to, but we have not been able to come across any Khatian number 135, patta number 288, tag number 293 in the said partition deed, my
Tag number 493.
tag number 293, my lord. 293 new, patta number 288.
In Khatian?
And Khatian number 135.
This is the photocopy. Where is the original, whether it has been already produced before the court or is there any?
My lord, because since I'm not a party to the suit, my lord, I do not have any access to the document, my lord. They would be able to highlight those. But I can give them a copy also.
But most probably this document was is already furnished before the
Along with the written statement, most probably they might have filed, my lord. Supposedly, my lord, my argument is supposedly the dark number, if it appears also, just for argument's sake, my lord, then also could the learned trial court have passed the order because of the specific bar under section 63 and 74, my lord. because there is no jurisdiction conferred upon the civil court to pass any order with regard to acquisition matters. And thirdly, my lord, my point is that, my lord, this order, as my lord has seen, the petition was filed on 28/2/2025. Order was passed itself on the very same day, without affording any opportunity to the petitioners or to the plaintiff, my lord. Now, my lord, that is in clear violation of principles of natural justice. That is my third point. And my fourth point is, my lord, that without impleading me as a party or impleading the DC as a party, my lord, the order was passed as a blanket, my lord, blanket order saying that either to the plaintiffs the amount could not have been disbursed or to other persons, my lord, who are not even party to the suit, my lord. That itself shows the illegality that was passed through the said order, my lord. And my lord, the land has already been, I have been informed yesterday, my lord, the land has already been acquired, my lord. I have been dispossessed. I had that land only, and now I'm a landless man. And in this regard, my lord, I'll be relying upon two judgments. I have already given the judgment, still I'm punishing the copies, my lord. Firstly, 2005, 2005 3 SCC 492. Paragraph number, the whole judgment, my lord, basically expresses a concern about the violation of principle of natural justice, my lord. Paragraph starts from paragraph number 7 till paragraph 15, but I'll not be reading upon all those paragraphs, my lord. What I'm relying upon is paragraph number 10, 11, and 14.
Yes.
Paragraph number 10, I'm first taking, my lord. Para 10, the adherence to principles of natural justice as recognized by all civilized states is of the supreme importance when a quasi-judicial body embarks on determining disputes between the parties or any administrative action involving civil consequences is in issue. These principles are well settled. The first and the foremost principle is what is commonly known as audi alteram partem rule. It says that no one should be condemned unheard. Notice is the first limb of this principle. It must be precise and unambiguous. It should appraise the party determinatively the case he has to meet. Time given for the purpose should be adequate so as to enable him the opportunity. The order passed becomes wholly vitiated. Thus, it is but essential that the party should be put on notice of the case before any adverse order is passed against him. This is one of the most important principles of natural justice. It is, after all, an approved rule of fair play. The concept has gained significance and shades with time. When the historic document was made at Runnymede into 1215, the first statutory recognition of principle found its way into the Magna Carta. The classic exposes so-and-so. Paragraph number 11, my lord may take up. Principles of natural justice are those rules which have been laid down by the courts as being the minimum protection of the rights of the individuals against the arbitrary procedure that may be adopted by a judicial, quasi-judicial, and administrative authority while making an order affecting those rights. These rules are intended to prevent such authority from doing injustice. Para 14, concept of natural justice has undergone a great deal of change in recent years. Rules of natural justice are not rules embodied always expressly in a statute or in rules framed thereunder. They may be implied from the nature of the duty to be performed under a statute. What particular rule of natural justice should be implied and what context should be given case must depend to a great extent on the facts and circumstances of that case, the framework of the statute under which the inquiry is held. The old distinction between a judicial act and an administrative act has withered away. Even an administrative order which involves civil consequences must be consistent with the rules of natural justice. Expression civil consequences encompasses infraction of not merely property or personal rights, but of civil liberties, material deprivations, and non-pecuniary damages. In his white umbrella comes everything that affects a citizen in his civil life. So, my lord may go to the other paragraphs also. There are a lot of citations given in this case, my lord. But here also in our case, my lord, no opportunity was given to us, neither to the plaintiff, my lord. The court held that, my lord, since the matter is pending or a sub judice, so it will not cause prejudice in any manner. But the court below failed to appreciate, my lord, that I am not even a party to the suit, my lord. . And the second decision, my lord, 2013 3 SEC, page 66, para 13, my lord. Short judgment, para 13. It is clear that the Land Acquisition Act is a complete force in itself and is meant to serve public purpose. By necessary implication, the power of civil court to take cognizance of the case under section 9 of the CPC stands excluded, and a civil court has no jurisdiction to go into the question of the validity or legality of the notification under section 4, declaration under section 6, and subsequent proceedings except by the High Court in a proceeding under Article 226 of the Constitution. It is thus clear that the civil court is devoid of jurisdiction to give declaration or even bear injunction being granted on the invalidity of the procedure contemplated under the Act. The only right available for the aggrieved person, this is important, my lord, is to approach the High Court under Article 226 and this court under Article 136, which self-imposed restrictions on their exercise of extraordinary power. So like this judgment also says, my lord, what Section 63 has already stated, that, my lord, civil suit is barred under this act and no order can be passed in any acquisition matter, including an order of injunction or restrictive order, my lord. So my respectful submission is, my lord has already gone through the order and the statements that my judgments I have given, my lord. So my lord may kindly set aside the order dated 28 to 2025, my lord, because this is causing very big hurdle for me, my lord, because they are not going to be prejudiced any manner, my lord. If they get the compensation, they want to get the compensation, they can approach the High Court under Article 226, or they can approach the reference court, my lord, but not to the civil court. It's my response.
Lord, first of all, the petitioner third party has no locus standi to challenge the order dated 21 to 2025 passed by the Learned Civil Judge Junior Division number 3. My lord, in annexure, they have submitted annexure in TS page number 21. Annexure A, page number 21. Para number 3, 2 and 3. That the original owner of the shoot land along with the other land was late Turabali of village Suprakati Noyabari, who had maintained right title, interest and possession over the same. After the death of Turabali, his two sons Abdullah and Sirajuddin, the father of third party petitioner, had inherited the shoot land and other land and constructed a residential house over this woodland and also maintained right title, interest and possession over this woodland and other land. Para number 3, madam. After the death of Said Abdullah and Sirajuddin, the plaintiff legal hero Abdullah and Sirajuddin, the suit land and other land maintained right title, interest and possession in Ismaili. But after final partition, register partition deed number 2978 dated 19/5/2024 of SR Office Karingon, the plaintiff got the below first schedule land and the other land in their absolute share and have been maintaining right title, interest and possession over the below schedule 1 land and constructed Pata house with the knowledge of all, including the defendant. My lord, whenever a deed was challenged, madam, challenge under this partition deed number, the source of title of a third party petitioner and the respondent, we are the respondent, are the same way by way of inheritance. The original they have mentioned in their TS ma'am, owner of Turabali, original owner of below schedule.
No. Sorry, we are not going to discuss on the right title interest of the parties at this present case. His only grievances is that that those dags and patna numbers or the khatian numbers were not the suit land, but in spite of that, the order was passed restraining the any person or the plaintiff petitioner from receiving any compensation. So that is his only grievance. But right title interest you may have because they are the third party. They are not challenging that thing. That the right title interest of the parties, etc., are not the subject matter of this case.
My lord, in
Yes.
the said PS, ma'am, my lord, the third party, the plaintiff is the cousin brother of third party. Third party executed a register partition deed 2978.
Who executed?
Register did number.
Who executed?
Oh, third party petitioner. The petitioner, third party is the executed of this said partition deed.
Third party petition.
A third party petitioner. The present third party petitioner.
Now this execution
Of the-
participant deed is in challenge.
Challenge.
Under challenge.
Challenge.
Then why if they are not the party? No, I'm not following you. You're saying that this partition deed is executed by the third party petitioner.
Third party petitioner.
Then why they are not the party in the suit? Why?
The title suit is filed by his cousin brother, in whose favor the deed was executed. Joshimuddin, his cousin brother, another. They have filed title suit, my lord.
Third party petitioner's cousin brother.
Cousin brother. Among them, they have executed this partition deed.
But
And this partition deed includes the share of our respondent share also included this partition deed, and they have on the strength of this partition deed they filed the TS upon their source of title on the basis of this registered sale deed.
Sale deed? No, partition.
Partition deed. On the said partition deed, alleged deed, ma'am, here in first party share in para number 12, ma'am, Mauza and Patian number 135, old dag number 252 obliques 457, and new dag number 293.
These are the disputed land. It is not disputed. Disputed dag is 293 or whatever Patian is 135. This is the admitted fact.
In our counterclaim, we have submitted counter written statement and counterclaim.
You are defendant here in this case.
Defendant, yes.
Now here in the your respondent numbers 1 to 5.
5.
1 to 5.
1 to 5 and 9 and 10.
1 to 5, 9
and 10.
So basically you are the defendants.
Defendant. Yes. Defendant 1 to 5, 9 and 10.
Here also you are the respondent.
Respondent 1 to 5 and 9 and 10.
Plaintiffs are not here.
Plaintiffs are not here. Well, to be precise, my lord, they have challenged the partition deed. Plaintiffs have not challenged. They have challenged the partition. So they ought to have made us a party, my lord. But my lord has pointed out.
Annex 2, my lord, page number 35. Written statement and counterclaim submitted.
You in original case you are the defendants.
Defendant.
So you are saying that the cousin brother of the third party petitioner had filed the instituted suit.
Yes, yes.
So who challenged the partition deed?
We have challenged.
You have challenged the partition.
We have challenged in our counterclaim in this title suit. We have challenged the said deed is void, fraud, and illegal policy. We have challenged in our counterclaim in page number 41. Counterclaim page number 35. Counterclaim page number 41. Para number 13.
See, as a whole, you just submit on the main subject of this case. Now, your title may be there, may not be there. We are not concerned about it because plaintiffs are there, defendants are. So, you as a defendant, you have filed your written statement as well as the counterclaim. And while filing the counterclaim or at the time of the written statement, you have challenged the partition deed. That is understood. Now, subsequently, you filed a petition that these are the land where already acquired and compensation may be given. So, compensation not to disburse because it may affect you.
Yes.
Isn't it?
Yes.
That is your case.
Yes.
So on that basis, the order was passed, even not listening the other side, that is the plaintiff. The third party question was not arranged because he was not even the party at that time. Though he, the cousin brother, may be cousin brother or whatever, but he is not the party. The third party petitioner in this case was not the party. So now you have filed a petition on the basis that if the compensation is being dispersed, then you may be affected.
Yes.
Because these pata and these are concerned with this. That is your case.
Yes.
Now, who is the owner? Who is the title deed holder or whoever? That is not our subject matter of this case because it will again create more complicated issue. Now, their main intention or main subject matter is this. I have gone through the order of the court. When it specifically stated that though it may not be the suit and all, but the petition deed contains this patta, this deed and all. So it may affect. So accordingly, the order was passed. Now they are claiming the entire deed of partition. This DAG number 293 or patta number I forgot so and so or the Khatian 135 is not mentioned here. In that regard or any regard, what do you want to submit now?
Yes, mention, ma'am. Yes, this partition deed, ma'am, in first party share, third party petition.
Tell us where first party share?
Para number 12, ma'am.
Para number?
12.
Para number 12.
Para 12 for partition deed. It's not here, right?
Para 12 for partition
deed.
Yes. What is it?
Mauza Lakarkai, Khatian 135, old DAG number 253 and 457. New DAG.
Where you ready? Para 12.
12, middle portion.
Halilong, bulilong, kiba ki likha ase. Purbe.
Mauza ki.
Para 12.
Partition deed.
এটা কত?
Itu.
Kaya ko kaya magtuturo. Yeah. Better? Good. The other one, the copy which is supplied by the other side, the petitioner. Your copy is not with us. Hey, guru, I feel
আছে আৰু
Para 12.
Yes.
Lord, come to page number 89. Javamanti
No,
copy.
what is para 12?
Page number 89. Javamanti
Para 12, what do you want to show?
Para 12.
On para 12, what do you want to show? 135 Kotiane?
Old dag number 253 oblique 457 patta dag and new dag 293.
দেখা পোৱা নাই অসমীয়া আখৰ নহয় জানো কিমান কৈছে 252 হে দেখা পাইছো 250 দেখা নাই
New dag is not mentioned here, but it is when Kotian
As
is
per you, what is the old dag?
old dag 253.
Yes,
52, 52, 52.
Old dag is
250, 52.
old dag is 252
52.
আৰু patta number
Patta 180 new.
new is 180 old is
Patta 288, my lord.
hey old
Old 250, 52. New dag 293.
এই তলত কি বস্তু এইটো যে মানে এইটো দূৰ দাগ নে পতা নে কি
dag number patta number. Yeah. 1%. Patta.
oh patta number
Kotian, my lord, there is no mention
Nine.
new dag. In Kotian, there is no mention.
now see the main challenge is your challenge is that you are challenging this deed of partition, isn't it? Deed of partition, wherein you are challenging that though the disputed land may not be may contain the dag number so and so, but in the the disputed this your compromised partition deed, those name dag numbers and patta numbers are mentioned because they are also there. But here we are not finding it. Just I was asking you to show me. Two things. Can you follow me?
Yeah.
Now, one hand you are saying that this dag and patta number as per the plaintiff case of the plaintiff, dag and patta number are 298, 498, okay, 293 something. These are the new dag and new patta number, and these are the under 135 Kotian number. These are their plea. Now you are saying that though these are the patta number, suit land of so and so, but entire partition deed is under challenge, isn't it? And the partition deed it comprises of those dags also. Those dags also in the compromise petition. So that's why we need that this should not be disbursed. So now show me from your compromise this partition deed where are those dags? Because the court also observed that those dags are there. So better not to disburse the amount because these are not challenged. Some matter is
Yes, my lord. As per my information, Your Honor, when the paragraph number 12, old tag number.
Yes, where,
Or Kotian number is there.
where is that page?
Para 12, Your Honor.
Of the partition.
This has been partition.
A partition date
Right.
in
Yes.
prayer.
Yes.
Prayer to who?
Not prayer, my lord, paragraph 12.
Paragraph
After paragraph 12.
Para
yes,
12.
yes.
Para 12 of the partition date.
Huh.
Sang Moza.
Sang Moza Kata.
Boy Zoria
One.
135. Kotian 252/457 number. Tag. Old tag, I mean. Purbe. Kutubali.
East side Kutubali, southern side Moinuddin.
My lord, what they want to say is that, my lord, these are the old ducks. These have been converted into new duck numbers, and that's why, my lord, the court held that, my lord. But
252 is the old duck.
old duck and the new duck number is 293, but it is not reflected, and the patta number is also not there, my lord.
Javamandi. In Javamandi, ma'am.
89. Yes, my lord. Kindly come on page number 89, Your Lordship. On the basis of the said partition date, one Jamabandi has been muted in the name of the plaintiff. Third party petitioner. Page number 89, Your Lordship.
89
And where,
of
yes.
the petition.
Yes.
89, yes.
89 page, my lord, as the column portion, Your Honor, registered date number is there and registered date is also there. Registered date means the partition date, Your Lordship. On the basis of the partition date, the third party petitioner name has been there. And patta number 288, new.
No, their name is to there. They are admitted. They are the patta holder. It is not disputed.
Yes. Our new DAG number, Your Honor, 293.
That is admitted.
Just is to admit it. Admit it. That they are
That
the
is why
patta
we're
holder is
claiming.
admitted. Is it disputed? No, I think.
Yes, it is disputed.
It is disputed. They are not the patta holder. No, third party petitioner is a patta holder. Is it disputed fact?
Disputed.
You are disputing that fact.
Yes,
This is the main case, Your Honor. And for this,
they have muted the said land on the basis of this alleged partition deed. And this partition deed is challenged. All the share in this said that our share 50% share is our.
Oh, this may be the matter of challenge. I won't disagree with you. Their claim may be there, their falsity may be, mutation may be there, mutation may have been under challenge.
Right.
These are all right. But my only contention is that as per the plaint, the tag number, patta number, schedule of the plaint, the Katian number, different number. 135 under 135, there are some tag number, patta number. And you also admitted in your written statement, these are the suitland. But subsequently, a petition was filed that though the suitland is not comprised with tag number so and so, but these are the tag numbers which are the restrainment order was there. These are the tag numbers wherein the here mentioned in the partition deed and which is under challenge. Then in that case, the court observed that matter is sub judice before the court as the entire deed is under challenge. So that's why the restrainment order was passed. Though basically this partition deed does not, the partition deed contains the other drugs also, these drugs also. So that is the thing. So now I'm just asking you, you want to show me where is the land here? Is any mention is there about those drugs and pattas where the restrainment order is made? Just show me the order to put a schema number page. Where is the order?
order of the
Imprint order, page 91. ma'am.
Now your submission is here. It is that the opposite party defendant filed the objection and submitted that although the tag number
Yes.
293 is not specifically mentioned in the schedule of the plaint, obviously not mentioned, or the counterclaim, sought for declaration of so and so. But the declaration concerning the deed number so and so, it is pointed out that the said deed pertains to land situated in Moses 135. The defendant also submitted a photocopy of the memorandum so and so, corresponding to say deed includes the land covered under tag number 293. Yes, 293 is there, na? Like now. Prior to the impugn order, the earlier order, where is the earlier 28?
Earlier order, my lord will find it page 75.
So your main DAG is the new DAG is 293 and patta number 288. And with khatia number 131. This is the main suit land. Okay. This order was passed in connection with only tag number 293 and pattern number 288 only.
293, 288, my lord.
That much only.
293, 288. That is what I'm telling, my lord. But 293 and patta number 288, that is not mentioned in the partition deed. In partition deed, my lord, what they are pointing out at paragraph number 12 is dark number 252 and 457. Patta number is not mentioned. They are saying that, my lord, 252 is the old dark number that has been converted into new dark number 293. But where is the document, where is the pleading to show that, my lord, that 252 was the old dark number and 293 is the new dark number? If my lord goes to the written statement come counterclaim, not a single paragraph or a line or a word
So
is
you want to submit that the said partition deed, there is no mention about
My lord.
293 and or 130.
My lord.
Old or new, whatever.
My lord. In fact, the patta number is not mentioned in para 12, what they are suggesting, my lord. Patta number is not even there, my lord. So even if I agree that 293 is there, which patta, my lord? There may be a lot of pattas, my lord.
My lord, in Phatian, there is only mention in old DAG number. After the Phatian, then issue patta. Accordingly, issue patta. Patta number is later on patta was issued. After the before that, Phatian is include only old DAG number. When the patta was issued, then new DAG and patta number was issued.
So where from you are saying that 252 is the old DAG?
Exactly.
Older Phatian is same. Phatian produced, my final Phatian is produced. Yes.
No, here 252 is mentioned.
Mentioned. Phatian number is 135. It is final.
Number 135, then where
Page
is
number 3, madam. Right?
Huh?
Right, follow. Tag number.
Tag number is
252. Public 457. 457.
that is okay. Your final Khatian is issued in for 135, Khatian number 135, and DAG number 252 and 457. Is old DAG.
Yes.
And you are saying that after Khatian only, the new
It
DAG,
should-
new DAG,
patta was
patta
issued.
was issued and new DAG. Now, where from you are saying that this old 252 now converted to 293? Is there any? That is only simple question. You are basically saying that 293 is the new DAG number, but and you are producing this Kotian also, where from we have seen that 135 Kotian is there and 252 DAG is there. It's okay, no issue. Now, where is the document from where you are saying that 252 is converted to 293 as a new DAG number? Is there any? Is there any document?
Sita Jamanmandi issued page 89.
Surveillance Jamanmandi.
89.
89. Annexure 11.
কিন্তু
They have-
পঢ়ি আহকচোন, একো বুজি
petitioner
নাপাওঁ।
submitted
কি দিছে একো ধৰিব পৰা নাই।
Sita Javan Mandi.
Of the petition, your lordship. Petition of the
petition বুজি পাইছো, এইটো একো বুজি
89
নাপাওঁ।
page.
কি
Page
লিখিছে?
number 18.
আধা আধি নাই।
Sita for
There's no,
survey.
nothing is there. It is
But
not legible.
you are mentioned 293, 293, the old
No, no,
new
it's
dag
not
number
there.
and patta number
It must
288.
be like-
Here is mentioned.
Itu online usah ulu.
কি দেখা? 292 is it? Who দেখা পান?
But the Javanmati has been provided by them.
Not legible.
Highlight for it.
My lord, page number 89 in the Jamabandi, your lordship. 293 is the pata number, dag number, sorry, dag number, and 288 is the pata number. And here Abdul Hamid's name is also there in the mutated column. And the registered deed number also there, 2978. And registered deed date also reflected.
And any other submission?
Yeah. For this registered partition registered deed, your lordship, the respondents has been also filed and share case, your lordship, before the Coimbatore CGM court. And on the basis of the share case, your lordship, on cognizance has been also taken.
Share case? Why? Why share case?
Share case for the forgery deed. This deed.
Claiming that this deed is a forgery.
Yes.
Who filed this case?
The defendant.
Third party respondent.
No, my lord, myself.
Huh?
Myself complaining.
Respondent number 1 to 5 and 9 and 10.
Oh, to defendant.
Or defendant. Defendant. So on the basis of the said deed also, we have filed a complaint before the district commissioner Sri Bhumi on 19 to 2025. The copy has been also sent to the complaint TS NCR case counterclaim. The deed number also already everything is mentioned.
That is your submission.
So our submission is there. So
Rightly
deed-
passed the order.
may not be.
Yes. Your for the respondent number 8 and 11.
Lord, I'm looking for 7, 8, and 11. State of Assam party.
Government.
So what is the cases regarding mainly what they are confusing, the basic thing, that this land is regarding the release of the compensation amount to the parties. And that one of the party is Abdul Hamid, that petitioner, I think, that is his name. Now, it is true that Abdul Hamid was found in possession at the time of the acquisition. His name stands at number 1 in our record. That is true. Now, what they are confusing both the parties, in a land acquisition case, who is the owner, that is not that important. Only thing that is important, who is found to be in legal possession of the land that is actually acquired on the date of acquisition. And the law is that the money should be paid without delay to the people who are actually in possession, who are found to be in possession, in legal possession. My lord, here the other parties, it has come out from what I heard today that they are in permissive possession. Abdul Hamid, he is the others, the respondents today, they are in permissive possession. And regarding the ownership, there is some litigation going on. So that we are not concerned. So what my lord will have to see is that I will give what our records are showing, the names of the parties. So my lord, because these cases may go on for another 30 years. So the people whose land has been taken away, so they should be paid, my lord. It should not be unnecessary, limitless delay. So that is very important, my lord, because these cases, there will be appeals, even maybe to the Supreme Court. They will go on for 30, 40 years. Does that mean that this land acquire, the compensation amount will be forever held up? So that, my lord, will have to decide. And we are giving all the required things. My lord, I'm giving a copy that was sent by the DC. My lord will get all the names and the account under which the amount has been deposited by us as revenue deposit until we get the legal permission to pay the amount to the party. And my lord, and if there is anything missing in this paper, I'm giving a copy. So my lord may go through, I think that will clarify everything. And my lord may not, the parties and my lord may not confuse with the ownership, my lord. This is who is in possession, legal possession. Only thing is, if somebody is in illegal possession, you will not get the compensation amount. But here, illegal possession has not come here. All the parties are in permissive possession, from what I get from the papers. Illegal possession has not come here. So that is that, and whatever they can be done, my lord, if they want the parties, they can, if they have some doubt regarding the apportionment between the parties, they can file fresh papers before our office.
Your this paper, once you have said that the third party petitioner was found in possession.
Yes, Abdul Hamid, yes.
Whatever.
His number one, my lord, will find in para 10, in page 1.
So as per you, he was found in actual possession of the land.
Yes.
Now regarding the apportionment, what you saying, the other party was also
Yes,
there?
now they may be having some problems regarding the way we apportion the money, because when we acquired the land, we found that this party is in possession of this much of land. So accordingly, it will be divided. So regarding that, they may still go and clarify things if they have some doubt regarding their position. And now, the main thing is, my lord, this is not a court of evidence, my lord. How will my lord know who is owner of what? There is no point going into that. No, in this, there is no, the dark number that is in the court orders. Court
My lord, dark number, patta number, my lord, I have also given copy, page
court
88,
orders are there.
page 88, and the notice that was issued at additional affidavit, page 12. There, my lord, notice was issued to me to acquire the land. Page number 12 of the additional affidavit, and possession certificate was also given at page 88. Page 88 of the main petition and page 12 of the additional affidavit. Admittedly, land was taken from my possession. I was found to be in possession. May I just read out page 88, my lord? It will clarify. This is to certify that a plot of land following description has been found under the possession of one Abdul Hamid, Nurjahan Khanan. These are my sisters, my lord. So and 5 other names are appearing. Name of Moja Lokhar Khai, name of Porgana Kusiarkul, class of land Chara, dag number 293, patta number 288, type of ownership, patta holder, total area of land 16 kotha, 15 chaka. And in paragraph page 12 of the additional affidavit, my lord, that is the notice that was issued. My notice is hereby given that you are deemed to be interested person in acquisition of the above land. Therefore, if you are willing to accept the sum of money fixed for compensation, price of your acquired land in Zirat as per section 23 and 30 of the Act of 2013, then within 3 days from the date of issue of the notice dated so and so at 11 a.m., you being all the joint owners of the land shall appear in person or any person authorized by you in accordance with or along with the appropriate documents. My name appears in both the documents at serial number 1. With regard to the fact of possession, my lord, there is no dispute. That is what.
Yes, my lord, I agree with that. I have seen all the papers, my lord, even the respondents, they may be having some disagreement regarding this and that. But actual possession, there is no whisper about that any party that I had given, my lord, is in illegal possession. So only if somebody is in illegal possession, the compensation of for land the compensation amount of the land acquisition can be withheld. Not because of ownership and all that. Because that will go on for 30, 40 years.
But they have challenged that part of it. You're saying legal actual position and legal position is quite different.
Yes.
Legally, whether legally acquired land is different thing or possession is different thing. Definitely, as per your survey, they were found in actual possession of the land. According notice is also issued in before acquiring the land. But you cannot say they are the legal possession. That legal position cannot be because they are challenging that position or that thing. That is it. So at this point of time, you cannot say the legal position, but yes, you can say the actual position. They were found in actual physical position over there.
And now, my lord, if they want to show this legal, if somebody is in illegal possession at that moment, or if they have
saying legal and
so
illegal.
what if they to show that that has to be evidence will have to be taken, my lord. Then otherwise, is it not possible, man? That is the problem. And one more option is there for the petitioner. They can implead themselves into this case, my lord. Why they are not doing that? That is one surprising thing. This Abdul Hamid, he should implead himself in the case where he filed that, which was dismissed. Without impleading, he had filed that. So after impleading, he will be able to send his witnesses and do whatever is required in that case. So that is one thing they can do, man. Well, I think that petition they are asking, they had filed that without getting impleaded, my lord. So I don't think my lord will be able to interfere until they get impleaded in that case. They have not gone together.
As their interest was affected, they appeared as a third-party petitioner, and their petition has already been heard by the learned trial.
Yes, but before
It's
that,
not
they
the
should
case
have
that it
impleaded
remains
themselves. Before that, they should have impleaded themselves,
It is
and
okay,
then
that is
after that,
different aspect. But they immediately filed a petition as when the order of arrestment was passed. That's why they have appeared and immediately filed.
In fact, the affected person can very well file an appeal also, my lord, without getting impleaded. If the interest is affected.
Interest is
So my interest is affected, my lord. Why should I get
So
impleaded?
what
Otherwise, that will also take years to come, my lord. Implement, they will file objection, then they will file CRP against the implement, this, that, my lord. 2-3 years will go by, my lord. By that time, my money, I'm a landless person now, my lord. What will I do? Again, this petition will be decided.
No, I think their case is that if they can show that they are in legal possession, I think they should get the money. That is the. And for that, I think it is advisable they should get in the impleaded. And if their petition is dismissed due to some reason, they should file a proper appeal. Because here, this is not a court of evidence, my lord. It will be very difficult.
Yes. Okay, any other submission?
I'll just submit, my lord, just 5 minutes. My lord has already gone to para 12, my lord. I'll just retire my lord, just for my well, para 12, dark number is 252 and 451, my lord. Nowhere it is mentioned, my lord, that this dark was converted to so and so and so and so, and patta number is even not mentioned, my lord. So if it is left to the imagination of parties, my lord, what dark number was converted to what? Then for whims and fancies, my lord, any party, interested party will say that 252 was converted into 293, my lord.
They have issued page 89, I think.
Page 89 is the copy of Sita, my lord. I have given the Jama Bandi also, that my lord will find at page additional evidence. Additional affidavit, my lord will find at page 13. They have what they have submitted is a copy of Sita. Additional affidavit, page 14, my lord, is the copy of Jama Bandi, translated copy of Jama Bandi. Implement application, my lord. So well, there also patta number 288 landed. That is, my lord, confirmed, my lord. I am the owner of 288 and 293, my lord. That is no dispute with regard. But my lord, this dark number was previously 252. That document they have failed to submit, my lord. Plus, there is no application, no pleading also in the written statement come objection. That this dark number, that is 293 is the new dark number and old dark number was 252. So in absence of any pleading to that effect, can the court ipso facto suo moto can help that this dark number was that dark number, my lord? That is left to the imagination, my lord, then this will be a very big burden. It will create chaos. And if they are anyways aggrieved, as my learned friend has spoken, my lord, submitted, that my lord, apportionment, if there is any dispute, well, section 73 is there, I have already read out. They can very well go to the collector, my lord, collector will refer it to the reference court. But civil court is not the proper forum. That is my reference submission. The civil court has absolutely no jurisdiction, my lord, to pass any order, my lord. More so, my lord, when I am not the party. They have said that, my lord, they are challenging the partition deed and they are also disputing that I am the absolute owner. If they are disputing that I am the owner, my lord, why not make me a party? Why to get an order behind my back? That itself shows their illegal malafide humor. And my lord, all the notices that were issued to me, acquisition notice plus my lord, possession certificate, everything was issued in my favor. So why I should be deprived of the compensation? If they want, they can very well file a money suit after that. Or they can approach the High Court under Article 226.
Well,
It's a never-ending business. Yes, what do you want to say?
in our counterclaim, we prayed for declaration the alleged deed style as partition deed number 2978, dated 19.
That is not challenge. That's
challenge.
admitted.
If the learned civil judge junior division allow our counterclaim, then what is the position? And cancel the deed. Then what is the position of third party?
No, they are not on that. They are saying that even if suppose your partition deed is declared to be as illegal one or cancelled, suppose, in that case also they will not be affected because their DUG number is 293 someone whatever, and the partition deed itself doesn't say that 293 or DUG number so and so is in the partition deed, and your counterclaim is of some other DUGs, I think, for other DUGs, not 293.
Upon the strength of this partition deed, the third party is the owner. Owner of the tag number 293. On the strength
But
of
they are not the party here.
they have not implemented as a
Not
party.
implemented as the party then. No, I'm not on that. I'm just saying that you are saying though that if suppose in the case in the event your counterclaim is allowed and the partition deed is stated to be illegal or forced or whatever, it is cancelled. No, but their strength is there that 293, DUG number 293 or whatever they are in possession of the actual possession of those DUGs and number, and your partition deed doesn't speak about the DUG number 293 or patta number 288 in your petition, and there is no document at all. That is their subject. That actually, I have passed the order. I'll pass the order.
On the basis of the registered partition deed, Your Honor, the Zamanbandi mutation has been completed in the name of the.
Yes, that is not disputed.
Here, specifically mention the deed number and registered deed. The registered deed number, registered is the
See,
same.
that is the mutation is in their favor, not disputed.
Yeah.
On the strength of the partition deed, they have claimed that mutation deed is already in their favor. Just only point that where is the case wherefrom we will come to know that 293 DUG number is there in the partition deed itself. On the basis of the partition deed, the name has been mentioned. Mutated.
For this,
No.
for this purpose, Your Honor, we have submitted 2 times a representation before the District Commissioner Sri Pumio.
Yes.
Last time we have filed a representation on 19/5/2020, 19/5/2004. Thereafter, remainder has been given by us 19/2/2025.
What kind of this representation?
For this, not to mutate the land on the basis of the registered deed 2978.
But your thing was not entertained or what?
Still date
Not hearing us, the circle has done the mutation.
Maybe illegally may petition.
Yes, it may.
We are not on.
Now the title suit, the status of the title suit is
PW are expired.
All PW expunged.
No, PW 1 and 2 are
They have not come for cross-exam.
cross-examined.
You have not? Why expunged? You have not cross-examined. Or they have not appeared.
They have not
Acha, okay, that's why it is expunged.
expired.
where is that the third party if implemented or we have no any objection. So it may be.
Here too, it's not a matter.
The learned could rightly pass him. Rightly pass the order.
So
Kindly
that is your submission.
dismiss the reason.
Good order is passed. Okay, I'll pass you.
Obliged.
Any? It was the appeal of which year?
Well, April of 2025,
25.
Judgment was also on 2025,
Petition is outside. Appellant is outside, I think, na?
Fine.
That's why it is not. Appeal is of 2025. None appears on call for the appellant. Heard Mr. V. Sharma, the learned physician PP, appearing on behalf of the placed a matter after 4 weeks as on a date.
Regarding the item number 39, the LIC, this false claim was done, the bill matter,
Yes,
13, Here my submission was that the doctor and nurse and pharmacist not verified the documents, and without the verification, they have placed before the doctor and doctor also signed it for a fake death certificate. That is there my submission. And on that pretext, I submitted that they may also involve. That is
No,
my
just
submission.
one. They did nurse, doctors, bank officials, me also involved in
My
this
lord,
case.
my
Yes.
lord,
Without any verification, they have signed.
my lord,
I have already,
my.
because the doctor also signed it.
Yeah.
And one bank official, he admitted that it was my
He used
mistake.
the ID of the my
Yes, without having any ID and all, he signed this. The documents are there.